The webinar is now live.
Okay, so good evening, everyone. I believe all of our commissioners are here. We may be missing one person, but we're going to move forward. So good evening. I'm William Johnson, Chair of the Baltimore County Blue Ribbon Commission on Ethics and Accountability. It's my pleasure to welcome my fellow commissioners, members of the public who are viewing the session of the Baltimore County Blue Ribbon Commission on Ethics and Accountability. Let me start off this meeting by wishing happy holidays to all who are celebrating holidays and wishing blessed holy days to all who are observing special holy days in this season. And of course, wishing everyone a happy new year, as this will be our last meeting of 2022. So I just wanted to get that out of the way so that I won't forget to do it at the end of the meeting. And so again, just happy to see everyone who's here. During this meeting, we will continue discussing what our commission members have learned from our fact-finding work since our last meeting and potential recommendations. As in previous meetings, I would like to remind everyone about our housekeeping items. The session is being recorded. I'm sorry. The agenda for tonight's meeting was shared with the members of the commission directly and is posted on the commission's website, which is www.blueribbonethics.ubalt.edu. The meeting is scheduled to conclude at 8:30. If we cover the agenda items before then, the meeting will close early. All agendas, minutes, meeting links, and commission materials will be posted on the commission's website. We will not be responding to comments or questions posted in the chat. Questions or comments can be shared with the commission by email at blueribbonethics@ubalt.edu. The commission members will have the opportunity to ask questions or comment during the meeting and can do so by raising your hand or using the raise hand function in Zoom. So I want to move to a review of the minutes of the previous meeting. And those minutes were provided to commission members by email on yesterday. Do any of the commission members have any comments or changes to the drafted minutes? Okay. If not, can I have a motion to approve the minutes?
So moved.
And a second?
Second.
Okay, thank you. So the minutes are approved as distributed. At our last meeting, we discussed the issues that have guided the work of the commission, including those that developed through the course of our fact finding. We will discuss those issues tonight, as well as the new issues that arose at or since our last meeting. Members of the commission will also be able to raise any other issues that you believe should be discussed as we proceed through this list. The goal tonight is to develop a draft recommendation on how the county should address those issues. We're going to attempt to get through this list tonight. So I encourage commission members that if we can, to keep our discussion of each issue to roughly 5 or 6 minutes or so, if possible. But again, we're not going to rush through it. We want to make sure that we're getting it right. And so if it takes a little longer, that's okay. And so we're going to go ahead and get started. And the responsibility for investigations only with the first issue, responsibility for investigations only or investigations and audits. And I think that's the organizational structure and accountability subcommittee. And so if you would, and if there are others you want to just, keep as we go, Kathy, that's, I'm sorry, that's not Kathy, that's Janine, right?
Yes.
Then that's okay. Okay.
All right, good evening. And on this first issue about the responsibility of investigations only, our subcommittee, as stated before, we think that it's operating fine the way it is with the separation between the audits and the investigations. And so I'll turn to the subcommittee members to see if they wanted to add anything or whether if there was a question from any other commissioners. Okay. Or concern. So hearing none, Mr. Chair, I do think that we are ready to make that recommendation that the current structure as it is with the responsibility investigations only and the audits are separated and it remains that way.
Okay, can we get general consensus on that recommendation? Does anyone object to it?
I concur.
Okay, okay. And if I can hear from everyone else, that would be helpful. So we want to make sure.
I concur.
Okay,
I concur.
I concur also. Our subcommittee touched on this and reached the same conclusion also.
okay. And I also concur. And even though we're not taking an actual vote, we do want to make sure that we have consensus. And so we have consensus on that one. And so we can move forward to the next. Topic.
So the relationship between the OIG and the Ethics Commission, I'm going to turn to my fellow subcommittee member, Tom, for a brief overview of that.
Thank you. Yeah, we do think that there is a tentative consensus that the Ethics Commission be separated from the OIG and that a new executive director for the Ethics Commission be hired. There was one subcategory in terms of where the office should be placed, and we're still working on that with the Schaefer Center to follow up with a couple of leads we had that we wanted to ask them about that. So we don't have an answer to that part, but as to the rest, we think it should be, they should be separated. Should I go into the reasons, or when there's consensus, just kind of let other people give their 2 cents?
Okay, yeah, so on that, is there any discussion on that part of the issue in terms of separation? Yeah, I believe we have consensus on that, and anyone who can let us know. But that being the case, yeah, Tom, you can just move to the next piece.
So the next issue was staffing of, well, we have general consensus on that. We will move to provide look to ask any additional questions and get additional information and provide that back to you. Well, the staffing of the OIG was the next issue. In general, we looked at that, and there seems to be additional staffing needed based on the resources and current workload. That funding source and the way is yet to be determined, but we did look at that and thought that additional staffing would be warranted.
Okay. Any discussion on that issue?
I was just going to say that in a certain, it's related to the Ethics Commission piece of it, because if we remove the Ethics Commission, it frees up the Inspector Madigan, who was spending a lot of time on the Ethics Commission work, to presumably do a little bit more work on her core function.
Okay. Any other discussion on the issue of staffing?
So I would just say that there is one of the new employees that came out of the increased census in that department, is, as I understand it, we can ask Ms. Madigan to confirm it. As I understand it, she is working primarily, I believe, on Ethics Commission matters. Certainly she is working on Ethics Commission matters. So I'm just saying it's not only Ms. Madigan.
Oh, okay, okay.
Yes, yes. Well, it'll free up resources in the department, maybe put it that way.
Okay, and that employee, you're suggesting would remain with the OIG, not move with the Ethics Commission, correct?
That's correct.
Okay, just wanted to be clear, make sure we're clear. Cindy, is that, do you understand?
I have no idea what anyone's intent would be. It might be that somebody would want her to move over to where the Ethics Commission would be. I was simply making the point that with respect to the current resources, given the increased census, that there is this additional person who is actually, I believe there may be 2 people, actually, one who had been hired before and one who's been hired since the new budget, who's working on that. Now, whether they would move over and still work on the Ethics Commission and have there be an additional person hired in IG, I don't know what would be appropriate for that.
Mm-hmm.
So let me recommend that we put this over to the Office of Inspector General for feedback, and then we could make a final recommendation pending that additional information.
Okay. All right. Any further discussion on that topic?
Nope, I'll endorse that.
Okay.
John, it's over to you to discuss independent legal
Yeah.
counsel. Thank you.
Thank you. As we discussed at a prior meeting, I think there's broad consensus, in fact, no apparent objection to the idea that the IG would have independent legal counsel. I think there are some subordinate issues, implementation issues that do have to be resolved. We could talk about them here if people who are not on the subcommittee have input, including those of you who are lawyers, judges, et cetera. And that relates to who decides when independent counsel is necessary. I also think it would be perfectly reasonable to ask both the IG and the county attorney to come to talk about that and see if there's a consensus between them. It's just a question of who gets to say. I'm not, one could say that that it should be entirely the IG's decision to do that. That there should be a presumption that that is correct if she thinks she needs, or he in the future thinks he or she needs independent counsel, that's it. The other possibility is that the county attorney would have to concur in that under the theory that at the end of the day, the issue is whether the county can continue to represent that independent counsel. I would trust the county attorney, not only this county attorney, but any county attorney, any attorney, to, in good faith, decide whether there's sufficient conflict and be willing to make that determination and allow independent counsel to be obtained. But there are other ways you could do it, and then you have other subordinate questions, including who would that be? I think our thinking is that it would be an outside firm, so that it's not someone who is essentially on payroll all the time, waiting to be called in case of a conflict, which seems to be a fairly rare occurrence. Therefore, you could use the county's procurement process or whatever the normal process would be to have someone on standby on a retainer. Again, I think those details are not for the commission. The details of how that firm or lawyer would be available, I would be willing to defer to the county attorney in the normal processes. And finally, the question of payment. I think it simply has to be a budget item. It is what it is, and it can't be that the OIG has to be concerned about that budget. But if the county attorney and the OIG or whatever mechanism decide that there should be separate counsel, then presumably that should be a county expense, and people proceed accordingly. So those are, that's a summary of the recommendations. I think it leaves open the only thing I think it really leaves open in what I've just said would be the who decides question. And other commissioners may have input on that because we haven't really talked it through. And as I said, I'd be more than willing to defer on that last and final point to get some input back from both the county attorney and the IG, just to see what they think. Obviously, our recommendation might be consistent with theirs, might not be. So that's where we are, and welcome other comments from both the subcommittee, of course, as well as the views of others who are not on the subcommittee. Thanks.
So let me hear some other thoughts on that, please. Kathy, is your hand raised? Sorry.
It is, but I can wait till I'm happy to hear your thoughts and then I'll chime in.
No. I was asking for other thoughts, so you're right on time.
Okay. I would concur generally that I think there certainly is a need for independent counsel, and I don't think any of us disagree with that conclusion or that recommendation. I think John is right. The mechanism for how it is something for further discussion and input. I do know that the county attorney's office has a mechanism for using outside counsel in certain circumstances. So I think Mr. Benjamin will be helpful in sort of talking us through of how they currently go through that process and what the approval process is to refer something to outside counsel. There may be instances where the county attorney is not conflicted from giving advice in certain areas that would be of benefit to the Inspector General during an investigation. So I do think it may make sense to have the mechanism be one where it's not like you're requesting permission to use outside counsel, but before using outside counsel, the IG checks to be certain that the matter isn't something that the county attorney's office is comfortable providing an opinion and guidance on. So there may be just my thought would be there would be a mechanism of seeing whether the county attorney agreed that there was a conflict, at which point the IG could go to outside counsel, so that we're not using a resource if it's unnecessary.
Other thoughts?
Just that if it involves the county attorney should have a designee make that decision.
Okay. So John, can you help us with just framing that as a recommendation? And just,
I think I don't know if I can do it in a more coherent sentence than what I did earlier. I'm happy to, I mean, I think it's sort of the elements of it rather than, I think we certainly agree that there should be independent legal counsel, that the question of decision is somewhat open, and I'll come back to that in a moment, that the independent counsel ought to be an outside counsel from procured by the county according to its normal processes and procedures, and that the costs ought to be borne by the county. Again, I don't think it's for this commission to get into how the county budget works or how the county procurement process works. I have no idea. I'm sure they can figure it out. I frankly think, and you may hear me say this again from time to time in the course of the discussion, I do think as we get to these finer points, I think it makes complete sense for us to ask for some practical input and advice from the people who actually have to do this after this commission goes out of business. And, you know, in this instance, that would be the IG and the county attorney. Again, we're not bound by what they have to say. And frankly, nobody's even bound by what we have to say, but it's sort of a best information we can get. We are fortunate to have a very capable county attorney and a capable IG, and we should just ask them. We should say, assuming we're going to do this, what do you think would be the most practical way to do it? And we might say, we hear you, we don't agree. We might say, great, but to the extent we can do that, and I think there are other areas where again, it makes sense. I don't want to see us do this in a vacuum when we have in the wings, and sometimes even on the call as an attendee, people who will have a view of this.
okay, we lost John for a moment. But I think we get the, just what he's saying. So Kathy, is your hand raised again, or is it just never went back down? Okay.
The only thing I would want to add is to capture Cynthia's point about if the county attorney proper is conflicted, then there's somebody else that makes that decision.
Okay. Okay. So based on what we've heard, the discussion that has already been held, do we have general consensus on independent legal counsel for the IG, and of course the details would need to be worked out? Yeah. Okay.
Yes.
Okay, good. So we can move on to the next topic. And that would be written policies and procedures. So I believe Kathy, that would be.
That is us. Thank you. Under the legislation, section 3-14-1068 requires the office of the OIG to establish policies and procedures. What currently exists are internal only and are marked as confidential. I do think from various sources in the course of our fact finding, the office would benefit greatly from having clearly identified policies and procedures. In discussing this point, what we have struggled with is too strong, but what we've kicked around is the fact that we don't want to micromanage this process and dictate what the policies and procedures should be. But we do think that certain things, that the language in that statute could be strengthened to require that they be external policies and procedures in addition to whatever internal operating guidelines they want to have. It's important because I think it is helpful to the office and is helpful to those dealing with the office to have clear expectations of what certain types of meetings or interviews are intended for, how they're going to be run. So people come in with clear understanding and don't feel surprised or put off by the process. I think that the office has developed their own policies and procedures. They're just not well known or identified throughout the county. Our thought is that we recommend strengthening the language in the statute to require written policies and procedures that are available to on the OIG website, that they're drafted in a way so that there are clear and unambiguous for people of average reading abilities, that they be available in multilingual fashion, so that generally we make the practices well known and well understood. We had some further thoughts that I would characterize as sort of best practice guidance. At a minimum, we thought that the policies and procedures should define the various types of interactions the OIG has, whether it be a meeting on background versus an interview, that they define how interviews are scheduled and conducted to include a clear policy on recording, a clear policy on the right to counsel, a clear policy on who, if anyone else, could be present in an interview, a clear policy and clearly reinforce the duty to cooperate, clear policies on confidentiality and whistleblower protection, clear policies on whether requests for recordings or interview notes would be honored, and a clear policy on whether or the extent to which notification of outcomes of investigations would be provided to someone who's a known subject of an investigation. So our thought is that we could strengthen just sort of the sense of understanding of how the office operates if those things were readily available. The other thing that we had discussed in terms of sort of a best practice guidance is in the city IG's policies and procedures. They also had a clearly articulated set of priorities for what things would be investigated by the office in terms of how they use their resources. Again, this isn't something I think we should mandate. I do think it would be the benefit to the office to have clearly articulated priorities. By way of example, in the city, they prioritize matters where significant decisions were awaiting completion of investigation, or where there was complex criminal activity or high-level employees or high visibility programs. They had, 5 or 6 different identified prioritizations. And we think it would, again, just benefit the office and benefit the interaction within the county if those things were clearly understood. So it was our recommendation that there be clear identified policies and procedures that are published and readily available. And then we had within that recommendation a series of sort of best practice suggestions. We're not intending to or recommending that this commission dictate what the policies are, but we certainly think that they should be clear and unambiguous.
Any discussion around that topic?
I would agree with Judge Cox.
Me too, me as well.
Okay, so do we have consensus then? I've heard from Janine and Tom, and see Joanne shaking your head, and
Yes.
okay, John and Cindy. Yes, okay, thank you. Okay, so we have consensus on that topic, and so we can move to the next issue.
I think the next is our committees also, which involves communications about new investigations with county or agency leadership. Our subcommittee is recommending that the OIG not be obligated to notify supervisors or agency heads before conducting interviews, as we feel that that could have a chilling effect on an investigation. Certainly the OIG should promote an atmosphere of cooperation within county government, where doing so doesn't impede an investigation. And the OIG may consider in appropriate instances sharing information with an agency head or supervisor in order to help secure cooperation and assistance. But in our view, how that happens and when that happens is best left to the discretion of the IG. So we specifically are not recommending that there be a policy that requires the IG to clear things in advance or schedule through agency heads or others.
Okay, so we're open for discussion once again on that issue. Any questions or discussion with regard to that? Janine?
I generally agree. I do think, though, that there has to be some nuance to that, and I can think of that in 2 levels. A employee who is maybe working, that worker bee employee who is not fully knows policies, procedures, regulation. Someone from the IG's office comes with this documentation, I need to talk to you. And their response might be, you need to talk to my supervisor because, or, they want to step out of the office and not be there at a date to be somewhere else. And they're not going to do that because they're supposed to be at their desk 5 days a week from 9 to 5. So there's got to be a little nuance in that and understanding in employees where they sit in an organization and some of the limitations that they may have or feel they may have, not just to not show up one day and say what to their supervisor, oh, I had an appointment, that might not fly. So I'm looking for some nuance in there. And then the same at the other end of the spectrum, usually for an executive, at the executive level, there might be some notification at that level to ensure that there is complete cooperation or awareness of what's going on at the within the work group. So thoughts.
Some of those thoughts, in one of the later topics that we're going to cover, we talk about sort of our suggestions on integration of the IG office within the overall sort of fabric of the county government, in terms of ongoing training for people about what the expectations are, rolling out a better policy, and reinforcing those ideas. Because I do agree that those tensions can exist. So it may be that we come back around to that topic in a later part of discussion.
Any other thoughts on that area? Let me hear from some others.
I mean, just that I agree with, I now that Janine is explaining, like I can see where, especially the entry level staffer, is being called in and you can't tell your boss what you're leaving for, and you also can't just go. So I do think there needs to be some consideration. I just don't know what it looks like, because like, where do you tell the supervisor that they're going without tipping off them, without tipping them off that they're being interviewed about a potential investigation of that actual like agency head. So yeah, just that I agree though, like thinking about the employee and how they navigate that situation. I don't see them being able to just walk out for an hour or two to go take an interview without explaining why they're not present.
Clarification. I thought what you were suggesting was that the OIG does not have to go to the supervisor. Did your recommendation extend to what the employee can say or not say?
Not in this topic area. We do have recommendations in another area in terms of the duty to cooperate and reinforcing the duty to cooperate that already exists under the statute. And I mean, the discussion around this point came from comments or suggestions that we had received at times from others, that before an employee, an agency employee is interviewed, someone expressed the view that that should be cleared through an agency head, that you shouldn't be talking to your people within your unit without it coming through the head. I mean, we do think that clearly undermines the independence of the office. We had approached it, therefore, from that standpoint. There is this, how do you protect the confidentiality of people that may be cooperating in an investigation? That certainly is an important concept. And I think the IG, currently navigates that and will continue to navigate, because each situation is different. There may be instances where you have reluctant witnesses within an agency and the IG feels it appropriate to go to the agency head and say, we're talking to your people, can you reinforce with them that they have a duty to be cooperative with us? There may be other instances where the target is somebody who's in a position of leadership within an agency, and you want to do just the opposite. I think some of this we just leave to the discretion and sensitivity of the IG to handle as they do the myriad of sort of complications that arise in any investigation.
Can I just say that, you know, this was not the subcommittee in which I served, so I'm trying to process these recommendations so I can provide, you know, perspective on them as part of the larger commission. And, you know, you're in a way, Judge, you've been focused, your committee is focused on some things that are a little bit more, well, not a little bit more, they are the policies and procedures as opposed to some of these larger overarching, you know, fundamental issues, independent counsel, et cetera. I just assume that there is nothing novel about these questions. And I just, you know, it seems to me that there ought to be a standard practice or best practice here that addresses these very concerns. I mean, these issues come up. These are the issues. And if you were an IG in the federal government or Montgomery County or the state of Louisiana, or, you know, whatever. So I'm just wondering to what extent we can tie these things. And I agree with you also that we shouldn't be micromanaging them. But, you know, if there are best practices in these areas and there's an association and there's a set of resources available to the IG from peers, surely there must be some way that these questions are managed. I mean, they're micro, but they're not like super micro. They're not peculiar. These are the questions that always come up when you're trying to figure out how to run this in a way that is equitable and transparent and all the things that we're concerned about.
I think that I agree with that, except to me, I mean, it's like when you teach police how to interview. You know, they all go to training and they all are taught, you know, what are the best sort of techniques in interviewing, but how that plays out varies from officer to officer to officer. And part of it's a function of personality, style, philosophy. So I think the overarching principles are be sensitive to confidentiality, don't undermine investigation. Like there's certain things, but to take it the next step and say, and it is the best practice to do it this way, I don't personally believe that you get there. It's like hearing, you know, I mean, I don't know how many times we've heard the phrase, if you've, you know, seen one IG's office, you've seen one IG's office. I think some of what we've seen in the background investigation here very much reflects people talking about things that are a reflection of the personalities of specific individuals involved in the roles currently. And I think we have all struggled to make certain that our recommendations aren't a reflection of, you know, personality driven decisions. It's how should the office be structured? So on this, you know, to me, it's clear you're not required to screen things through an agency head. It's clear you have to have very firm policies on confidentiality and protect the people that you're interviewing. But how that plays out, I don't think you can drill down much further than that.
Yeah. Okay. Well, that's well said. I appreciate it. And, you know, I do accept that, but okay. Well, thanks. I think that's a good explanation. And I realize we're trying to strike a balance. So let's keep at it. Let's keep going.
I think
I do think though that there are places, to your point, John, that there are places where in the federal government, if you're under investigation, or not if you're under investigation, but if if an employee under investigation are being interviewed, the head of the agency may be notified of X. I mean, it's not uncommon or unheard of. And I believe, and I'll try to find it in writing. I think that some sort of parameter or some nod to it or some spoken word about that to acknowledge that as a thing is something that would be needed, particularly as I raised the issue of a subordinate in an organization going to an interview or missing for a couple hours. And if we're,
So,
Yeah, did that factual situation come up in Inspector Madigan's testimony anywhere? I'd be curious to know how she currently handles it.
It didn't come up specifically in our discussions with her.
Okay.
It didn't frankly come up as a problem with the various employees who came to talk to us either. I mean, there was some reference to people being contacted after hours or to meet at a different time and location. I certainly, you know, I had the sense that that there's a sensitivity to this issue. But, you know, we can certainly, There are a couple of things that our group needs to follow up on with Inspector Madigan to just get some clarification. And we can add this to the list.
I'm strictly referring to process, not any, whether it happens in Baltimore or not. I'm just strictly, or whether there's a sensitivity to it or not. It's just process. That's all I'm focused on.
Mhm, mhm. Okay, so it sounds like that there is some consensus around not it not being a requirement. And so we want to make sure that that's clear, that we're not making a recommendation that the IG be required to inform leadership of an investigation, but that there may be some nuance, as Janine says, workaround where, there may be some instances that's left up to the discretion of the Inspector General when, if possible, they may want to let leadership know. So we can kind of look at, how we might want to word that, one, and two, we can take a closer look at how some others may be handling that and see if there, John, if there's something that may be considered best practice in that area. So let's say we have consensus on the one part, but let's go back and do a little more on it, if that's.
Can I go back to one sentence that was in our original discussion, sort of this concept? We did have in there that the OIG should consider sharing information concerning a referral with an agency head or supervisor to help secure cooperation and assistance and to ensure that, information relevant is received. So it is a dual sort of recommendation, not required, but certainly be sensitive to the inner workings within county government. And I think we will double back around on this when we come to the confidentiality recommendations.
Okay. And that sounds like it may cover then what we were trying to get at. Okay. Any other discussion on that topic? And do we then, based on what Kathy just read, do we have consensus on that? Let me just do a check-in. I see Tom saying yeah, and Cindy and Joanne, Janine, okay, and John. Okay. Then we'll move on to the next one.
This to some extent is an overlap with the earlier on policies and procedures. In terms of rights of investigation witnesses, our recommendation, or what we're asking to the commission to recommend, is that the rights of investigation be clearly identified in a written policy and procedures manual as discussed above. And again, while we don't want to dictate specific practices, we think it would be best practice to include clarification of the following things. One is to define what's an investigative interview, because there does seem, we did get multiple comments around what's an interview, what's a background meeting. We think that they should define the practice of what an investigative interview. Intuitively, it's, once an open investigation is proceeding, that they're asking to sit down with somebody to obtain information in a more formalized setting. We suggest that they develop a practice for how to place someone on notice that they're being requested to appear in an interview, that there be guidance on their website for interviewees as to what to expect in an interview, that there be clarification, a clear and unambiguous policy on who may be present. I think the current practice is that somebody can bring counsel if they choose to, but no others to be present, but that should be stated so someone goes into it knowing that. We think in terms of counsel being present, it should be clear whether counsel is permitted to sort of react and advocate within an interview, or they're there simply to observe an interview. So that they should have a stated policy on that. They should have a stated policy on recording. Right now, what is there is as a general rule policy. It is our belief that it would be a best practice to have a clear policy that if their intent is to record, that their intent is to record, unless somebody refuses to grant permission to record, or if there's some technical inability to record, and then what would happen, that those should be clearly defined in their policy manual. So those were our recommendations, which again, just go back to clear policies and procedures that are available and identified on a website for employees.
Okay.
I think those are all extremely good and exactly the kinds of things I was hoping we would get to. And also, I think you've done a good job of going deep enough to identify the areas where we would have those expectations without dictating the expectations. So I think that's very good. I do have one quick question, which is this idea about internal and external policy manuals, one of which is public and one of which is not. I wonder, Judge, if you have any thoughts about that. I mean, I'm trying to understand the difference, and I certainly understand the prerogative to keep some things internal, but I'm not sure what the dividing line is. Can you conceptualize for me the difference
Sure.
between those?
Sure. If you look at their current procedures manual, it makes references to other materials that are available that talk about how one office should operate. You know, investigative practices and procedures. They talk about certain rights and whether you're going to read them or not read them to people. It's done in a level for a person with a certain degree of sophistication in the internal operation of the office.
Right.
If you're somebody who works in the, finance office of county government, who's, a new employee, none of that means anything.
Yeah.
What you want to know is, why am I being called in? Do I need to bring somebody with me? Am I allowed to bring somebody with me? I'm anticipating that it would be in plain English. I mean, within the judiciary, there's a little department that does things about it, and I'm sure county government has it too, that makes things that are being published for, the average person to read, make sure they're in plain language, that they're clear and unambiguous, and that an ordinary reader can digest it and understand what the intent is. My thought is really a policy and procedures manual, so that there isn't this black box out there that people don't know how to interact with. It ought to just spell out basics for people.
Yeah, no, that makes sense. I mean, the way I thought of it in my own mind is like an FAQ, that whatever format it takes, online or in paper or both. And I mean, I don't mean to be glib when I say this, but it's a little bit like an FAQ that says, so you've gotten a call from the IG, and it's like here are the things we know what most, not all, but we know what most of the issues are that people will have questions about, because we have people who have testified to us, we've studied it, and we sort of know. We don't know them all, but we know a lot of them. I think having some very clear preemptive information about those would help to address some of the ambiguities that seem to be disturbing to people. And frankly, I don't see the return. There's no real return on that investment. It just seems to me that we need to be clear. I have heard the IG say, and I certainly understand this in view of the staffing, that to some extent they have staffing issues. To the extent that there's staffing that is affecting this, I think we have recommended that there be adequate staffing. The current budget year has additional staffing. So it may be one of these things where it's just trying to get it in balance, that we need more staffing in order to do these things. And once they do, so I don't view this as a complaint so much as just a growing pain. It's an evolutionary sort of thing. And, hopefully we can help diagnose those issues and help the IG stay ahead of those concerns that we've heard from people who have testified to us in various forums.
I think that's true. I think the other part of it goes to sort of initial rollout and training recommendations that we have. I mean, I think from my own experience, I think one of the things the county does very well is sort of these educational rollout things that you're required to do. You need to do your security training and all of that. They're adept at doing that. There could be online training that's available that says, these are the basics. You got to call. This is what you expect. It can be published. There are lots of ways to do it. And I think they're fairly sophisticated on how to implement.
Good. Thank you.
And I would just say that I really agree with the approach taken by the subcommittee, because I think you're trying to strike the right balance in terms of, you don't want to micromanage, you don't want to do anything to constrain the Inspector General in terms of how she does her job, but we want to make sure everyone knows their rights and responsibilities and what to expect in the process. And it seems to me like you're striking that balance pretty well.
Okay, thank you.
Okay. All right. Anyone else? All right. Do we have consensus on that issue then?
Yes, sir.
Great. Thank you. Okay, then we will move on to the next topic.
You're going to get tired of me. This is mine too. Reimbursement of legal expenses. this comes up because certain individuals have felt compelled or felt that they should have counsel with them, and then want to be reimbursed later for the expenses that they've incurred. Our feeling is that the county should not generally be required to reimburse for legal expenses for an employee who feels the need to engage counsel for whatever reason to represent them in an IG investigation. We did allow for the fact, and I think this is something that we need some further discussion and input on as to how you would implement this. There may be an unusual circumstance where reimbursement would be appropriate. And our example would be such as an instance where somebody is being accused of or suspected of criminal conduct. There was a potential criminal overlay that was clear from the outset. They felt they had to engage counsel and they're later exonerated in the process. Or later it's, even beyond that, not only are they exonerated, but it's shown that somebody was, malicious in the initiation of the complaint. There's the possibility of an unusual circumstances where it would be compelling that somebody should be reimbursed for the expense that they've undergone. What our group was trying to figure out how to craft a recommendation around is to put a piece in there that in the legislation that says, persons or individuals can bring counsel with them to an interview at their own discretion. Generally, the expense of that would not be reimbursed. However, for a person, in exceptional circumstances, an individual could petition the county government or make a request to county government for reimbursement. And we were unclear of if you did that, what would be the right chain for that to go through? Would it go to the county executive? Would it go to the CAO? Would it go to county council? If you did that and an investigation had been closed without any finding or report, is the person then disclosing stuff they want to have confidential? Just the mechanism for how you do that was something we didn't have kind of a clear path for. But we did want to leave kind of a safety valve for where it seemed egregious that somebody could request reimbursement.
So let me ask the attorneys on the commission, are there other legal avenues to address something like that, if that should happen? If you go into court and you're exonerated, are there mechanisms by which you can ask that your legal fees be covered, including your attorney's fees?
I mean, if it affects Rule 11, if it was done in bad faith, you can sometimes get attorney's fees collected, but the American system is everyone pays their own attorney's fees most of the time.
I completely agree with that. There's circumstances now where people are later exonerated that they can get reimbursement for certain, thing. There are these exceptional circumstance models out there. It may be one of those things that's so convoluted to figure out how you do it, and the possibility of it playing out doesn't make it worth doing. In general, we don't think the county should be footing the bill for counsel for everyone who feels uncomfortable going into an interview. It's like a blank check out there, and it is, people have a duty to cooperate and provide information, and they shouldn't be reluctant to do so.
Other thoughts? Nate?
Well, I agree. I agree with everything that's been said. I think that the baseline is you can't have that as a rule. Otherwise, not only will everybody want attorney's fees, but everybody will then want to bring attorneys even when they don't need them. And it's just going to back you up into a very unnecessarily complicated situation. But I also don't know what the mechanism would be. And, we could make a recommendation. I'm not sure that it depends a little. There's a question here about what is the commission's charge with regard to this recommendation? Meaning, we could say, we clearly believe that not everybody should, that there's a rule, there's a baseline, there should not be any reimbursement for attorney's fees. We can imagine situations in which that might be possible, but I don't know that we are in a position to take that next step. It's a question of how we feel about this. We could just simply say that it's something that needs to be studied. We don't necessarily have to make that determination now. We can sort of put a flag in the ground that it's something that needs to be looked at, and maybe it can be looked at, and the county will figure out whether there's an equitable way to do that. and they'll decide one way or the other. I mean, I'd be comfortable with that. I'm not sure we're going to be able to make a perfect, tie it up with a bow recommendation on all of these. So I'd be all right with that sort of a determination. The other possibility would be some way of gauging over some period of time retrospectively how much of an issue that has become. You know, I don't know how to do that exactly. I don't know what kind of data you could collect, because I agree that you can't, you know, to do it for the very, very rare instance just doesn't really make sense. And my sense is that it's pretty rare, but at least based on testimony and conversation. So, you know, I don't know that there's a real perfect answer, if you will, for that. But that's where I would come down.
Yeah, I'm not aware of any jurisdictions that would cover something like that, and what kind of precedent that would set if, you know, you began doing that. So, you know, just covering those expenses. But you know, the county is asking for our recommendation on that, and that's not to say that that would be the end all be all, you know, of what the county decides to do in the end. But they are asking us to just weigh in on that question.
Might it be a case where the investigation maybe is so fraught with incorrect information or not done well, where the person had to seek an attorney to try to write the document or the information that and then there's that what do they do with that? And then they're able to get an attorney and finally bring it to light that there were some inaccuracies, if you will, in the report or in the investigation. And maybe they've gotten an attorney to do that. But I guess to your point, that might happen so infrequently, it's not something that you could.
No, I'm sorry, go ahead.
I was just gonna, do they currently have the right in, you know, if they're gonna be interviewed, to seek someone from the union to be present for that interview?
I mean, certain employees may, I don't know. I mean, if you were dealing with police or firefighters, maybe.
Mhm.
I don't know the answer to that. I mean, it certainly, I mean, we get such a skewed sort of set of information in, you know, people reach out to us because they were either very happy with an interaction or very unhappy with it. So certainly in the latter group, there were people who talked about the need to get counsel and how they felt that, you know, they underwent sort of an expense that was unnecessary, blah, blah, blah. I get that. But I don't know if you really, and this goes to John's point, if you looked at the, you know, the universe of interactions that the IG has throughout the course of the couple of years that they've been up and running, how many people have actually had counsel at those meetings? And would any of them be circumstances that sort of from an attorney standpoint, the bad faith, you know, malicious sort of lack of substantial justification, those kinds of standards, how many of them would rise to that level?
Yep.
It may be worth suggesting that it be studied a little further when you've got a better factual record for knowing whether it's worth going through you know, the exercise of trying to figure out how you define what the exceptional circumstance would be where they could ask for reimbursement of fees.
This to me is a little bit in the category of what I mentioned earlier, that I kind of like to get some more information. I think the union question is a reasonable question to ask. I'm not suggesting that people represented by unions should be in a different or better situation than people who are not, but I just feel like we could use a little more practical input, and I still may come back to where I was, which is we're just not ready to sort of cross that line right now, but that people could take a look at it. So again, I don't think we're going to have a million of these, but I think we're going to have some where we're going to be like, can we just get a little more insight on this from people who have been living with it, and just to inform our thinking, and then we can sort of revisit it and try and finalize a recommendation. So, Mr. Chair, I don't know if that's okay with you, but I think we're going to, have a few of these. I wouldn't want to have a lot, but I think having a few is probably healthy at this point, because it means that we're really refining recommendations and we're realizing that there are some open questions like this that would benefit from a little bit of input, pardon me, from the people who are, who are working on this every day.
I agree, John. Yeah, and there's no expectation that we're going to come to consensus on everything tonight. So,
Right.
Well, I hope no one feels that way. If you have questions or we need to go out and do further work on it, then by all means, that's what we're going to do.
Yeah. And Judge, I don't, I really wouldn't know this. I defer more to the courtroom lawyers and the barristers and solicitors or whatever, how that goes. But at some point, presumably someone who has been sufficiently abused by the process is going to have these prerogatives anyway under Maryland law or Maryland right. I mean, at some point, I assume that you can't deprive people of pursuing a remedy if they feel like they've been truly, sort of unfairly attacked by the process, by their own government, et cetera. I mean, it's just a notion that I have. And that's frankly another thing that also ought to take a look at, because if you're trying to protect against egregious cases, and the egregious cases are potentially protected by other safeguards that exist, and maybe they are, maybe they're not, then there's no need to add them.
Yeah, I mean, you can, I don't know what category, I mean, the general category things would fall into is an abusive process category.
Yeah.
But in this instance where you've got a duty to cooperate, there's no process that's issued.
Yeah.
I don't know of a tort claim that you could,
Yeah.
like off the top of my head,
Right.
like you might be able to spin one somehow, but
Yeah. Fair enough.
yeah.
Sorry, I didn't mean
it'd be a rough
to
one.
make it more complicated. I'm sorry.
It's a good quiz for the evening.
If there's malfeasance on the part of the Office of Inspector General or just a dereliction of duty of some kind, then yeah, perhaps. But
It goes to Tom's point, though, there's no clear then entitlement to fees if you pursue it. Like you'd have a hard time finding counsel to pursue it because it would cost you so much to go there. It wouldn't warrant or justify it.
Mhm.
I think it is one of those things in my head right now, unless somebody pointed me to something in the county code, I don't think it's something that you could easily remedy or find as an effective remedy for.
Mhm. Yeah. Okay, so let's say we will put a pin in that and we'll table it and see if there's any additional information we can find on it, and come back to it in our next meeting. Is that okay with everyone? You good with that?
Sure.
Okay, so let's move on to the next one then.
The training for ethics, Tom, I'll turn to you to talk about that and how that wraps into another.
I'm sorry, are you talking, is this the ethical climate in Baltimore County?
Correct, yes.
Okay.
And
Yeah.
the training that we talked about.
And the training?
The training, where does it fall? I believe that's where does the training fall? Under whose responsibility?
Oh, okay. All right. I did not, we did not have any recommendations to take actions with respect to the ethical climate in Baltimore County. I know we're supposed to look at it in relation to the ethical climate survey, and the Schaefer Center, I mean, did an excellent job of putting together a comprehensive survey, and they were asking the right questions. I'm just not sure we can trust the data we received from that enough to justify, recommending any kind of legislation, because there are a couple of problems, as we talked about before, is that the response rate was under 20%. Of that, under 20%, 86% had not been involved in any kind of investigation. So it's really small. I mean, we were getting to the point where there were interesting findings, but some of them involved 50 to 60 employees out of 7,000 that were shown the survey. So I'm kind of concerned about making any definite conclusions about what the ethical climate is in Baltimore County. The other thing that kind of pulls me away from making any kind of recommendations is that, even though the statistics are helpful, we don't really have any benchmarks. So, for example, just to give you one example, when it says just over a third of people say that they've been subject to retaliation or a hostile work environment when they've reported something, that seems high to me, but I don't know what it would be like, if people in Howard County answered that or people in other states answered it. So we don't have enough that I can propose or our subcommittee can propose a solution that's going to increase or better the ethical climate, other than to the extent we have, an effective inspector general who will be able to root out any problems and deter people maybe in the future from, committing any ethical violations. That's what we should do. But beyond that, no specific recommendations for action. And as far as the location of ethics training, I was not clear in terms of, is that where it's going to physically happen, or who is going to be responsible for conducting it?
The question would be, who would be responsible for conducting it?
Okay. And I did not see anything that would cause us to change who does it. Whoever the entity is that does orientation and because that ethics training can be part of that. I think it would be beneficial to have the OIG go out and explain, kind of in terms of transparency, kind of go around and let people know, what it's all about. But I didn't have any recommendation, or our subcommittee didn't have any recommendation in terms of the location of the ethics training.
I would just add to that. I think at some point during our discussion, Tom, we did talk about if the ethics office, if there's a separate ethics office, the ethics office is responsible for the ethics training, and if the IG takes the part of the specific IG training, and it be a shared responsibility. I don't know if we need to delineate specifically where that line is drawn, but that they have to work together to ensure that it's a cohesive product that they're producing when they conduct the training.
Okay, I would agree with that.
So as a recommendation then that there would be I guess I'm going to call it a general curriculum ethics training that would be given to employees. Would this be for all employees, new employees? Just any discussion around that? What are we recommending here?
Yeah, I don't think we really got into that. I mean,
Is ethics training an annual requirement now? I think it is, right?
Cindy, you're muted. You're still muted, Cindy.
Right. Okay, here I am. So right now, and I believe this has been the case for a while, the Ethics Commission, really through the executive director, has given an ethics training, and this is required under the code. When I'm talking about ethics training, I mean ethics that is under the province of the Ethics Commission, which would be the provisions of the ethics code, which is not everything that someone might think is ethical or not, but rather is things like outside employment and conflicts. It also involves what you must and must not and may not disclose on your financial disclosure, that kind of thing. So that is sort of the ethics thing. I was about to say that it was unclear to me in the discussion we're having right now. If we are talking, when we're talking about ethics training, do we mean that ethics training about what is allowed and not allowed under the ethics code, which again has been going on an annual basis, used to be in person, and then in her role as executive director, Kelly created an electronic online, it created a different thing that was done in small segments and then ultimately online. However, there's also the issues of fraud, waste, and abuse, which is the category that comes under the Inspector General. And Normally, the word ethics is not used for that, like in the code, but in the broader sense, we could all think of fraud, waste, and abuse as being a type of ethics issue. I will tell you that to me, it would seem to be, other people could disagree, but to me, it would make sense. This is the way, again, it has been for a lengthy period of time, for whoever is dealing with what has been the Ethics Commission's role and the executive director of that commission to continue to deal with the training regarding ethics. I do think that there is a very good, that one could see that a need and a value in having training around fraud, waste, and abuse. It feels to me like this is something that could well be done in one training, right? With two different people coming together, and you could do it separately too. But just because I have to imagine that employees might prefer to not do many multiples of training in a given year, that perhaps, there could be a value in putting it together, but I don't know that it matters that much. So if that shines light on anyone, I was unclear as to whether what we have been talking about in the last several minutes has been ethics training or also fraud, waste, and abuse training. And I think that that is really one of the things that maybe was not clear, but maybe led to a little bit of the confusion that people were starting to have in this part of our meeting.
Okay. So that what exists now is ethics training, is what you would call ethics training.
Yes, it is called ethics training, as a matter of fact. Yes, yes, and right now, it is something that you log into and you look at some things and you answer questions. And if you don't remember to do so by your deadline, you get pinged and reminded that you have not yet done this.
Okay. So, Kathy, did I see your hand again? I'm sorry.
And just briefly, in the next area that we're going to talk about, we talk about training around duty to cooperate. I completely agree with Cynthia. I think that there would be a value to having training about sort of the overall role of the IG, what it means, whatever, be part of one of the recommendations we're making is that some of that be part of an onboarding process that is regular and routine, and then other would be just an ongoing training. And I agree also that it should be, cover the whole range of things because they're interrelated.
Mm-hmm. I do know that there are some organizations, one, as I recall, I believe with the state motor vehicles administration, they had a training module for new employees that really covered the whole fraud, waste, and abuse piece, where they did case studies and showed, what they considered to be fraud, waste, or abuse, and cases of previous employees who violated those policies and the outcome and some of the things that happened to them. And they, at least at that time, felt that it had a positive effect on kind of reducing some incidents of fraud, waste, and abuse within their system. And so, that would be a little different than Cindy, what you're calling ethics training that you have now.
Exactly. Yes,
Right.
and I would say, for what it's worth, is I think that the ethics training that Kelly has put together is really quite good and works pretty well. It's not something that, at least that I think of as anywhere close to being in any need of immediate change. But again, I guess what the judge and I are both saying from what we've thought about it is that having some educational component to the other side of things, what's really on the IG side of the house, is something that could be beneficial. And if these things are going to come out of two different offices, they could work collaboratively in doing a combined one, or they could simply have separate ones.
It does remind me, Kelly.
I-
Go ahead, John.
No, I mean, I think we're all saying the same thing. I would certainly support adding additional training regarding fraud, waste, and abuse, kind of the basic structures, so that people understand what it is. I think it's intuitive, but it does have legal meaning, and I think people should understand it. And I think the other thing is letting people know that there is an IG, what the IG does, because part of the recommendations that we've been talking about this evening are a little bit about the demystification of the IG, the OIG, the process, et cetera. And anything you can do up front when someone comes on board to sort of say, look, these are the avenues that are available to you. I mean, you'll have HR. I presume the HR onboarding process says if you have a discrimination issue or something, here's how to handle it. So I think this is the sort of the analog. If an ethical issue arises, here's how this works. That we have this thing called the Office of Inspector General. We've been talking about it for a long time, and we've internalized the idea that there's an OIG. An ordinary county employee may or may not be aware of this. I think there's a real service to be done to say to county employees as part of onboarding, there's an OIG, this is what they do, this is how it works, here's some information about it, et cetera, here's how to access it and the like. And I think that's all consistent with our overall theme to try and demystify and normalize the presence of the OIG within county government, that people start to appreciate the value of the role and how it works and what it does, and how it's maybe, as if our recommendations are adopted, somewhat distinct from the Ethics Commission function. All these things that are now sort of apparent to us because we've been thinking about them for so long, I'm sure are not crystal clear to people. And anything we can do to make that stuff clear to people is only going to be to the benefit of the employees and the county and the overall process.
I do think it's fair to point out, I mean, Kelly did give us a list of the trainings she's conducted. And I think she has taken this on and sees it as important and valuable in the role. I think what's not there, though, is something that mandates that be done. Or that requires that it be included in certain aspects of training within county government. So I think formalizing a recommendation for what I think she intuitively sees as a need, and all of us are agreeing is the need, would be a benefit.
I believe the code does actually provide for an annual ethics training, though, but we could expand upon that a bit.
Yeah, and I think that's what I'm saying, that we expand to include as part of that the ethics training, training on fraud, waste, and abuse, and do you cooperate with the OIG, all of it together as part of that.
Okay. And then there would need to be budgeting or staffing to help support that as well. The ethics training now, that's an online training, Cindy, is that?
It is, yes.
Okay, so it's not in person, but that's still, there's a cost, to developing that kind of a training even and maintaining it. So in terms of getting a consensus on a recommendation on this issue, the recommendation that I'm hearing would be that training on fraud, waste, and abuse is included along with the existing ethics training. I don't know if we want to say it that way, but in addition to the existing ethics training, would that be fair?
Yeah, I mean, I would just say not just on fraud, waste, and abuse, but on the existence and the role of the OIG and how you access it and what its function is and so on and so on. It would be fairly easy, I think, to summarize those things for people, but it would be useful for people to hear about it on the front end in a mandated way.
Yeah.
And I think clearly including the duty to cooperate.
Yes, ma'am.
And okay.
Retaliation, whistleblower protection, all the standard.
Yep.
Topics.
Okay. And I'm going to trust that our note takers have all of that and we'll put that together for us. So with that, do we have consensus then on that particular topic?
Yes, sir.
Okay, great. Okay, so
Mr. Chair, before you move on now, I just want to go back to the ethical climate and make sure we captured the recommendation around that.
Oh, that-
Consensus.
Yeah, there was no recommendation. The recommendation was to take no further action other than with respect to figuring out what we're going to do with the ethics training. But over and above that, we're not recommending any action.
okay.
So the recommendations that we just discussed, is that for a different area? I guess now I'm confused because we
The
were.
original topic was ethical climate in Baltimore County overall, and then during our discussions, we had dropped a subtopic new about training. So I just want to make sure we had the overarching topic that started the conversation, that we captured that.
Right, yeah, because it started out with the location of ethics training being a portion of that, and then ethical climate survey, which was conducted by UB, being the other other part of that. And so with regard to the ethical climate survey, there are no recommendations that we're making with regard to the results of that survey. Am I saying that correct, Tom?
Correct, yes.
I will, Mr. Chair, at some point, whether it's part of the agenda or not, I do think there are some sort of, not next steps exactly, but like sort of regular steps, if you will, that we might want to think about recommending. And I'm happy to think about this and circle back to you. But for example, one of them might be that an ethical climate survey be conducted every X years along the lines that we've just done. We now have a template for it. Presumably it's not very hard to do. You'd have to have somebody do it. But, you know, and I agree with Tom that you can't really tell from that thing whether the information you're getting is anecdotal or, you know, statistically, it's very hard, although it certainly was very helpful to me in at least thinking about things. I mean, at the very least, it's anecdotal. And there's nothing wrong with some good anecdotes to make you think about whether you have issues, and helps you probe and ask questions and all those things that we've done. So I think it's a useful thing to do. And I think, you know, people, it might be something, and again, I can put a pin in this, but I think that the idea of recommending that on a regular basis, whatever that might be, there be such a thing. And the reason I think those things are useful to do, if the group agrees, is because it removes the burden from the then existing elected officials and others to sort of decide to do it and debate to do it, et cetera. And obviously we can't make them do it. But if there's a recommendation like that kind of in the record, and people think it's a good idea, it's something that can be done going forward. So I completely agree that there's no action to be taken based upon the survey right now for all the limitations that it posed, which is not to say it wasn't valuable. I think it's very valuable, but I also think it could be valuable to do that on a cyclical basis. So I just kind of mention that. Maybe we can talk about it at some other moment, but I wanted to raise that.
Okay, and so that's so noted, and I would think, John, that we could also put under that, I believe at some point in one of our meetings, you mentioned the possibility of recommending a similar Blue Ribbon Commission every so many years to kind of review that may go under that same
Yes.
subtopic. And so
Yes, exactly. That's exactly. I mean, again, people may disagree, but I do think that it's worth at least talking about, you know, what can we sort of plant that is going to, you know, what shrub can we plant here that could be useful going forward, so that people don't have to think about whether it's a good idea to do it again. And, you know, this office is still relatively new, and I think people are going to find value in the recommendations that we're providing. I hope they will, but it will continue to evolve. And if we're 3 years from now, you'd have that many more years of experience and that many more anecdotes and some more data. So I think we should be helping this process along, and we should be thinking about ways in which to do that. But that's my advanced pitch for my ultimate idea, which I will, put together for you at some point soon.
okay. So
Thank you.
So we will look forward to that, John.
Thanks.
Thank you. Okay. Joanne, did that help you with your question?
It did. Thank you.
Okay. And so I believe we're moving to the county policy about employee compliance with OIG investigations. If I'm not mistaken.
I think that was a topic we had raised. That was a new topic last time that our subcommittee had talked about because of some discussions we'd had in other areas. And essentially it starts with, there are a couple points within it. First of all, the county executive had signed what was called a code of conduct revision in 2021-007. It was our understanding that had been signed, but had never been rolled out in the way that code revisions typically are, and I'm not certain what that entails. And it was done pending review of the recommendations of this commission. That code revision emphasized the need for people to cooperate with the Inspector General and talked about the importance of that. We were making two recommendations with regard to that code revision. One is that consideration be given to amending it further to include not only the duty of employees to cooperate, provide materials, be responsive, et cetera, but also that it is a violation of the county code of conduct for an employee to obstruct or attempt to interfere with an investigation or action by the OIG. So it's not just that you have to cooperate, but you can't undermine it or you're try to interfere, because I think both concepts are related and they're important. So we would suggest that we recommend that revision and then a rollout of that policy, whatever that means. This actually dovetails to the discussion we just had. We were saying that the rollout should include expanding a training around the OIG practices and duty to cooperation and what that looks like, making it a part of a regular onboarding process. So related to that, it was important that we also look at whistleblower protection and confidentiality provisions, because I think if you really want to have a robust atmosphere where people feel that they are comfortable and protected in cooperating with the OIG, you need to spell out those policies and make sure that they're as expansive as possible. Right now, the legislation that exists, section 314.110, talks about cooperation, and it provides that the names and identities of individuals making complaints and information, be protected, and that there be whistleblower protection. It should be clarified in our view to say names of individuals making complaints, disclosing information, otherwise reporting to or cooperating with the OIG, that those won't be disclosed unless required by law or judicial process. The current internal IG policies and procedures somewhat contradict that notion and say that the IG has sole discretion on publishing names, titles, positions in published reports, so long as publishing such information conforms to applicable privacy and freedom of information restrictions. To me, that's mushy. I think we need to really have clear policies that say that the persons who initiate an investigation, who are cooperating, et cetera, that their information will be kept confidential. There can be no retaliation. And then that be more expansive than it currently is. In reports, and I think we had discussion around this, in a report, in sometimes detailing the investigation and what was done and how it was done and what conclusions were reached, it is sometimes hard to avoid, even though you don't name names, it is sometimes, in making the report clear, hard to avoid identifying in a way that people can't kind of, read the tea leaves. So how you strike that balance, it's hard to, it needs to be drafted carefully, is I guess what I'm saying. And we should think of how that's worded, because we don't want to hamstring the OIG from writing a report that's understandable and clearly identifies what work was done. But names should not be used. And to the extent possible, you should avoid identifying information, including gender pronouns, et cetera, so that people's identities are not known. The last thing we talked about is, to the extent that it's unavoidable that, because of the nature of the investigation, that the subject of the report would be someone whose identity is clearly, you can figure it out by reading the report. Right now, there's nothing that gives that person, just before a report's going to be published, that may be very unflattering or whatever, that person doesn't have a right to any review or comment. So the other thought that we had was, to the extent that there is a clear subject of a report, that before the report is published and generally available to the public, that it should be disclosed to the individual with the right to review and comment back to the IG if that individual thinks the details in the report are inaccurate, that before it's out there and you can't claw it back, that they have a right to at least review it and comment. So those were our thoughts around those sort of related areas.
Okay.
Those all sound reasonable to me.
Open to any further discussion on those areas?
I just have a question, if I might, about the last point, the review and comment point. I mean, I just don't know how that works. I mean, I certainly get the idea, and it's certainly equitable, and, and I don't want people, if there's an opportunity to correct something that is factually incorrect, it seems like the process would be better for it. I mean, it's better for it to be accurate than not. But I guess the price you pay is that it sets off some sort of, I don't know, lobbying. I don't mean lobbying in a political sense necessarily, but sort of, it's almost like you want to pre-litigate the report. Like, it's sort of like, you have sent me this report, and now I'm going to send you a full brief on everything in the report. It's not just, a purely factual objective matter. It's the whole characterization. And I don't know how that works. And I don't know, I guess I would ask people whether that is common, in any of these situations where you have an opportunity, give someone an opportunity to sort of, see what the thing says. So I'd love to hear a little more discussion about that. Judge, I don't know if you have any, I'm sure you've thought through the sort of pros and cons of it, and I clearly understand the pros. I just don't know about the sort of cost benefit analysis in that situation.
It's in a more broad sense, one of the later topics, which is the number 14, we're asking for further discussion with the IG and with the CAO because of exactly those tensions. I mean, there are examples out there where there are factual matters being debated between the report, the county's response. There's a reply on one. I don't, in terms of undermining public trust and confidence, when the major players are debating facts publicly, and I don't think that benefits any of us. Everybody wants to get it right. And I think it's very hard when you come into county government where things are, complex and nuanced, particularly as a new office, to come in an investigation, kind of get all of those nuances. So, I mean, intuitively, there was a benefit to having that stuff play out before things are published.
Yeah.
That may be inaccurate or misleading. But I agree with your comment. You don't want to, you don't want to make the process of publishing a report a never-ending negotiation.
Yeah.
So we were looking for more information on how that could be best structured.
Yeah. Well, maybe again, it's something that we have to put a pin in and talk about. But I'm not, again, this is not the kind of law that I practice. But parties will stipulate facts when the facts can easily be stipulated, and the facts are the facts. But it's pretty rare that you read a legal filing of any kind where the parties are not arguing about the facts as well. And they're not going to, if you put them in a room, they wouldn't ever agree about the facts, because once you agree about the facts, it leads to conclusions and so on. So I just don't know how you avoid that endless loop thing. And yet it is so appealing to say, look, if we can tidy up a few things so that the ultimate report is cleaner and less subject to attack on sort of narrow objective facts, but that it's a little bit of a sliding, that's a sliding scale. Sort of what's a simple objective fact to you, maybe I may view that as a characterization. And so I just don't know the answer. I mean, I totally get the point. So I don't know if there's a way to try and work on that a little bit more to see if we can come up with a balance, and something that strikes the balance as best as it can.
It's our suggestion on item, I think it's 14, that we do exactly that.
Okay.
That we, that's our notion, but it's a work in progress, and it really needs to have further discussion and reaction from the people who would be implementing it.
Okay. Well, I'm fine with that for sure. So thanks.
Just two comments. I would think, or it's been my experience that during the course of an investigation, if there's going to be a finding that whoever's responsive to it, the appropriate person, there would be a dialogue between the investigator and that person to clarify any misrepresentation, lack of facts, missing holes, to give that person an opportunity to respond. And so thereby giving that opportunity within the scope of still the investigation being open before the final report is completed, and that being part of the final report. That's been my experience.
I think we clearly have comments, though, that in the context of how this office is operated, that's not a requirement. So I think that the tension is, are we going to make that a requirement? Is we making it a semi-requirement? Are we calling it a best practice? I mean, I agree it benefits no one to have, have a misimpression or a gap in an investigation that may not be apparent to the IG, but if you were, this
Right.
person, you would suggest they talk to somebody else who would have different information. I think it's important that we have as robust an investigation as possible before things get published, is I guess our concept.
Right, I would agree.
Mhm. I would agree also. Any other discussion on this particular topic, or do we need to come back to it? Do we have a consensus? How do we feel?
Can I suggest that the last item that I had on that topic, which is the notifying the person who's sort of the subject of the investigation, that we take that off the table for now and roll that in with item 14, where we are suggesting that it be further, exploration of a fund before we get to a final recommendation, because the other parts of what we're talking about under this topic are just the revisions to the county code to include the, violation to attempt to obstruct and interfere. And I think there was consensus around that. And then I don't know that we had really discussed the sort of making a little more robust the whistleblower protection and the confidentiality provisions. But I suspect there's consensus around those also.
Okay, so let me check in with that with regard to the whistleblower protection and the other revisions that have been suggested here. Do we have consensus to that portion of the recommendation?
Yes.
Okay, Kathy. So we're good for that then. And again, to our note taker, that we have consensus with regard to those revisions to the county code that would include making sure there's no undermining of investigations as well as whistleblower protections. So,
Okay, thanks.
okay. So let's move then to financial independence.
Yeah, that was Tom.
Yeah. That is one area in which we have not reached a consensus. I kind of think maybe I'm the lone holdout. But in any event, everyone on the subcommittee agrees that you got to have some level of financial independence, that OIG can't be effective if they know that, their findings, if they know that if they go after the wrong person, they're going to be retaliated against. Best practice is to actually tie the funding of the OIG to a fixed percentage of the general operating budget of the agency. In practice, that is rarely done, according from what the Schaefer Center published on the best practices. Only about 1 in 6 local government bodies have a provision like this. And I think I'll kind of summarize what I think is the majority position and my position. And if I've mischaracterized the majority position, I'm sure people will jump in. The arguments in favor of just kind of leaving it like it is and not adding this other protection, one is that there is already some protection, because what the county council has done has kind of charted a middle course. There's no guarantee as to their funding, but there is a provision that if they decide to reduce the funding, they have to justify that in writing. And I think the majority think that that middle course provides sufficient protection, that we shouldn't go any further than that. I got a sense there was some arguments maybe last time that the fears of retaliation are a little bit overblown, given the way the budget has been increasing over the last 2 or 3 years. My response to that is you don't know what's going to happen with the future county council. This council seems to be doing a reasonable job in funding them, but you never know if that's going to change. There's also the argument, why should the OIG be treated differently than everybody else? And my response to that is, they're in a unique position. They're the one agency that is investigating entities that control their existence. And so they are entitled to greater consultation. And what I thought was maybe the best criticism of it is that it's very difficult to determine what the proper percentage would be, particularly when you have a new agency that's kind of in a growth period. Where do you draw the line? My suggestion would be that we take the fiscal 2023 budget for the OIG and take that as a percentage of the fiscal 23 overall budget, and that will give you the ratio, and that would be a floor. If the IG continues to grow rapidly, there wouldn't be anything to stop it from doing it. So anyway, those are kind of the arguments going back and forth. There are also some other measures to protect the financial independence that we need to discuss. One suggestion was that we amend the county charter to make to provide for the OIG. In other words, make it a constitutional position so it can't be eliminated by a mere vote of the county council. That was suggested at the last meeting, but I don't think there's any consensus as far as whether that is a good idea or not. Another suggestion I had is if you take if people do not want to go as far as a guarantee of a certain percentage of the budget, is you take the provision that exists in which they have to provide written justification for any reduction in the OIG budget and change that to any reduction in the OIG budget as a percentage of the general budget. So the presumption would be that the OIG is going to increase in size at least in proportion to the way the county is, because as the county gets bigger and you got to have more employees, presumably the IG is going to have more things to investigate, and their budget should kind of go up accordingly. A final point that we don't have any consensus on is a question was raised at the last meeting about what would the enforcement, what should there be an enforcement mechanism for the requirement that they justify in writing any decrease? And I don't think they're ever going to ignore that, but you also had the problem that they could do something kind of pretextual to justify when they're really just upset about how an investigation was conducted. Do we need to put some teeth in that? That was the question that was raised.
Go ahead, John. I see you wanting to get in there. So.
And if I've convinced no one, then, the vote is 6-1.
I'll tell you.
Next issue.
Justice Glancy has really given us a lot to think about there. Look, we've talked about this in the subcommittee. I think this is a solution in search of a problem at this moment in time. And I just think, you're potentially creating all of these structural issues, including pitting the IG against other functions in government, which I prefer not to do. I want people to be supportive of the IG. I don't want it to become, why is the IG so special? I just don't think it's necessary right now. And believe me, if I thought that there was any history or any inclination to the contrary, I would be all over trying to create some sort of safeguard. I think the opportunity still exists to do that. So I just don't think it's compelling. All of Tom's points are totally reasonable, and are the right arguments in favor of that, but I just don't know that I could support it. I will say, and I forget the answer to this, maybe someone can tell me, whether the OIG is typically a charter or other constitutional level office. I know in the city it is, because I happen to know the city charter. I would be willing to support the idea of institutionalizing the OIG in the county charter. I don't see any reason not to do that. Obviously, you could starve it, I suppose, of money if you really wanted to, but I think it's a statement about the importance of the IG, that it would be not only a matter of code, but a matter of charter. I'm not an expert on the county charter. I don't know what typically goes or doesn't go in the county charter. And I also would like to know whether typically, beyond the Baltimore City experience, which I know, whether this office is in the charter or charter equivalent. But it doesn't seem unreasonable to me to do that. It's not going to solve, Tom, your problem. If there were folks really out to get the office financially, I guess you could have a OIG with no budget, but it would make it harder to do that, because the charter by definition would essentially be a indication of the importance of the office. So I guess those are my thoughts in reply to that. And those are very good. Thank you for an excellent summary. It was really good.
If we went the county charter route, and thank you, John, if we went the county charter route, I don't see any reason why you couldn't put, in addition to, there shall be an office of the, Inspector General, maybe add language saying that, and that office should be must be adequately funded by the county council, without specifying any kind of formula that they have to follow.
Yeah, we did that recently, actually, in Baltimore County. I think maybe it was 2020. All the years are a blur, but there was a program that passed, and it says in there that explicitly that funding needs to be made available without indicating how much. So I do think that's a good route.
Does anybody know offhand? I mean, just from recollection, or does the staff know whether OIGs are typically in the local or relatively local examples at a charter level or at a code level?
From our research on best practices, the majority are from legislation. It's not showing them as being in charter.
Interesting. Oh, okay.
But I will say in Baltimore County, especially based on the public's perception also, and I think if the council is supportive, I do think enshrining it kind of sends a message to the public that this is an office that is here to stay, and that there's, and that voters have made clear that they want it. So regardless, I think regardless of other jurisdictions have done it or not, other states, I think, again, we have to look at Baltimore County, the circumstances here, and, the public questioning whether or not this office will be maintained and so forth. So I think it's actually a direction I hope the council will, take that recommendation and run with it.
Any other thoughts with regard to that? And I think we kind of frame it now, and I'm not going to limit it to that, but this discussion about making a recommendation that it is placed in the charter, I think perhaps that is the definition of best practices and of Baltimore County perhaps leading the way rather than following what others have done, but maybe it's taking the next step.
I thought there was kind of I didn't hear any dissent from that, but.
Yeah, I just want to make sure, give opportunity for that, but hearing none. Go ahead, Jenny.
Okay, I'm fine with that.
You're good with that? Okay. And we know Joanne is, and Cindy, you're good with.
I'm fine with that. I was just looking while we were talking at the county charter, and goodness, it has quite a lot in it. And when I look at how much it has in it, I think to myself, be rather odd not to have the Office of the IG in it. It's my view. So I am supportive of the recommendation.
Okay.
And then I guess I'd ask if there's any discussion on the other suggestion that was made, that we craft some kind of enforcement mechanism in the event either the county council does not justify a decrease in writing, or they have a written justification, but it's pretextual. Should there be some remedy specified in the code or something or elsewhere?
I sort of share John's concerns about that we start pitting different things that are protected against other things and treating this differently than other, I mean, I haven't looked at the charter, and I don't know how long, and Cindy, you've got it in front of me. I don't know whether there are any protections like that that are in there anywhere, but assuming there aren't, I don't think we should just, I don't see a need to go down that road right now.
It's a bit of a long document, it appears. I've already closed it out anyway, so as to look back at y'all. But I would say that I generally agree with what John and Judge Cox have said.
And one point I would make is the concern about them cutting the budget or eliminating the budget based on history and what's going around on the rest of the country. It's a legitimate concern. I know that the Connecticut IG was, they did away with that office. We had the guy who was speaking about his experience in the New Orleans OIG, and their funding was cut for 2 months until they could get it back. So it's not an idle threat. And the fact that the OIG, I mean, the county council at present is funding it on an upward path is just no guarantee that if the OIG conducts an investigation that bites the hand that feeds them, that there won't be retaliation down the road with, a new county council that.
And I think we do have to look at this with future vision. We're not necessarily looking at the current players, that any of them would do such a thing, but we don't know what may happen in the future. With a future IG, with future county council persons. So I think we do need to take that into consideration, and that historically that has happened. So not within Baltimore County, but in other jurisdictions, as Tom has said, that has happened. So
As I understand it, if just to summarize, that we're not going to go to setting the budget as a fixed percentage of the operating budget. There's kind of a consensus with one person kind of maybe out in left field going the other way. But I mean, I get the sense that everyone else agrees that we shouldn't do that. The enforcement mechanism, it sounded like there was consensus that we don't need to add an additional enforcement mechanism. And third, it sounded like there was a consensus that we place this in the county charter and perhaps add language that it shall be adequately funded.
Yeah, I agree. And by the way, I don't have in front of me the code, but I think we've all seen it. I think I may have read it out loud at a prior meeting. But this provision about have to justify, I mean, we should look at it. Maybe it can be strengthened a little bit. We absolutely should look at it. But I don't know if any other entity in county government gets that prerogative where you have to publicly justify a budget reduction. I don't think that's unmeaningful. So again, look, it's not perfect, Tom, and I might regret it if in a future administration, assuming it goes this way, and in a future administration, someone attacks the budget, et cetera, I might say, oh boy, that was naive of us. But I just feel like for the moment there's enough in there with the balance of the recommendations that we've just discussed. And I would think it would be useful to take a look at that justification language and see if it could or needs to be tweaked to strengthen it, because I'd be okay with that too. But just not as far as the percent of the budget and so on, which I just think elevates it. I mean, I think we're all pretty convinced of the importance of the office, but I don't know that I feel comfortable elevating it when there are so many other things out there that, depending on who you are and what you're passionate about, you might argue deserve the same treatment. So that's my perspective.
And so, yeah, I agree, John. I think that the language should be reviewed just to make sure that it's clear. I don't have it in front of me either, but in reading it, I recall just having a question: who were they justifying it to?
Right. It was something I'm sorry I don't have it, but I think I may have thought something about what does that justification look like? Maybe you add the word publicly, maybe there's a notice provision. I just don't remember it. I thought there was something you could do to make it more overt, because I think it should be a high bar. Like, if you're going to do that, you should have to, justify. You can't just sort of do it and put the memo in a drawer.
Well,
So
I haven't thought
let's-
this through, but one thing that just came to my head now is if you go to fire the OIG, I think you have to give written reasons, and there has to be a public hearing. You could maybe add language that, a written justification, and that there be a public hearing on the issue.
I guess my only concern regarding I'm not opposed to it, but Baltimore County, I think already, or I'm hoping they have public hearings around the budget process. So in theory, if they are already publicized, yeah, they do, right? So if they are making this memo or whatever it is public, that is the opportunities, hopefully in advance of those hearings, that is when the public would get a chance to respond at those budget hearings.
Well, that makes sense. I mean, and this notion came into my head about 90 seconds ago, so it's not very fleshed out.
And at the hearings, are they only hearing the budget requests, or are they actually making these budget decisions? So if you have the hearing, you make your requests and your arguments, what have you, and then at a later point, they make a decision on the budget. Then, and they've made a decision to cut that budget. At that point, are they required to give justification as to why they made that decision? And I'm asking because I'm not clear. I've not been part of the county's budget process. So,
I mean, I guess before the hearings happen, typically, again, I can't remember Baltimore counties, but they release a draft. Yeah. So the CE releases his intended, budget. That is what the public responds to. If the council is, I don't think the council has the authority to lower. Again, I'm not familiar, but either way, there is a draft budget. If the county executive's office were trying to lower the budget, that is where the justification would also be released with it. Yeah.
Narrowly, I mean, this is a sort of subordinate point perhaps, but narrowly, I believe the county council only has authority to reduce, not increase the budget, which is sort of not really the exact point we're talking about, but it's sort of relevant to the.
I was going to say something that just came up in the chat from someone that said the budget is set by the county executive. The council can only cut the budget.
But that's what we're talking about, is cuts. So.
And if anything, the council is where I think the justification is really needed. If it's being proposed, why are you decreasing it? And hopefully that would come out before a final vote is made.
Well, it's two steps. Is the county executive's proposed budget reducing it, in which case it should be justified. And if the county council then proposes to reduce the executive's proposed budget, what's the justification? With whatever justification process we ultimately decide to recommend is, maybe it's an enhanced version of what's in the code today. And like I said, I'm prepared to live with that for some period of time before we go to a much more extreme version of it for all the reasons that I mentioned earlier.
And I think the language of the written justification provision does kind of cover that, because as I recall, it says any proposed or adopted budget. So,
yeah.
So there has to be a written
Sure.
justification at both phases.
I mean, can we not do, I don't know. I'm trying to think. Sometimes jurisdictions have impact statements. So it's more if you are trying to make a significant change in that jurisdiction in an agency, you are then not only providing your reason for why you want to do it, you are looking at the overall impact to local government if you were to do this. So, in this case, if the CE is trying to cut the budget, here's what, they're forced to take a look at the office, right? Is the office now going to have to reduce its staff? Is it no longer able to do trainings in the way that it was before, and so forth? So I think it should go further, not just the justification. It's like a full-on impact statement around, which isn't much work. They should be able to do it. But we want to cut this, and here's how it could impact the way the office functions if it's not doing away with the office completely.
okay.
Yeah,
Yeah, go ahead, Tom.
I wouldn't have a problem with that. I mean, if it's done in other contexts, I mean, it adds just a little modicum of additional protection for the OIG.
Okay. And Tom, I will say for the record that actually I agree with your initial proposal as a best practice, but I understand the concerns as well. And you know that perhaps there are some other workarounds, and I think we're coming up with some other workarounds. So didn't want you to feel like you were out there by yourself.
No, yeah, and putting it in the charter does provide some protection, you know, because you can repeal a statute, but it's harder to get around the charter provision.
Yes. Okay. So then our recommendation is that we would place it in the charter. And that there would be some language included in that with regard to ensuring funding. Is that everyone's understanding of the recommendation, and do we have consensus on that?
Yeah, and I guess the additional thing is, does a written justification have to include an impact statement? That was the other issue that was brought up.
Yeah. And I'd really think it's needed only because it also, again, forces them to have a conversation with the IG. How is this reduction going to impact your office? You know, she or whoever's in the role at the time would be able to provide them a real time, like an understanding of what that looks like.
Okay.
I'm sorry, just to clarify, Mr. Chair, where was that supposed to happen?
In terms of the impact statement, is that what you're?
Yes, is that just part of the general process, budget process for any agency?
Joanne, you can respond to that.
I mean, it's not. I don't think justifications are even, I mean, I do think sometimes when they've made a change, they will explain, but I don't even think justifications are required in other budget areas. So this would be something new we're proposing altogether.
You okay with that, Janine? Okay.
We kind of got way down the road. I think where we were originally, so I'm not clear on where we are with the language. From the original proposal or about general language. So right now I'm not really clear. No.
Okay. So let me, I guess, try to, and I think we kind of simplified it from the original where we kind of moved to really just moving it into the charter, having it placed in the charter, having
Right.
budget language put in the charter.
I'm okay with that.
That part, okay. And then the other part is the impact statement, that would go into the code, I'm assuming,
Yeah, I
right?
think so. Yes,
No,
without written justification and after, you know.
And this is where if there's a significant decrease being proposed to the budget itself. So again, many times, you know, you will see that, you know, Madigan herself, IG is recommending a budget for her office. She's going to explain what she needs in it. You know, they would sometimes explain, here's what you're getting and why. But I think, again, the additional protection, if we're going to go so far as to forcing a justification, then we should also require that they have that they have a full understanding of what, you know, this decrease in your budget is actually going to do. So it's not something huge. Again, they have legislative staff that would be able to quickly, you know, draft it up for them. It just forces a conversation before they're just saying, I'm going to cut, you know, $10 million from a budget.
I'm going to go back to the original statement that I thought we were talking about it not being a separate and something above, separate and above what any other agency would have to do. And earlier, if it were on, I don't know, law enforcement or something that's public safety, is that something that's in the public safety code, a requirement for their budget? There's a justification. I don't know, I'm asking.
I mean, I don't.
I would just say, I'm not troubled in any context for saying we're giving the OIG something that other agencies and departments, you know, don't get, because, you know, it is the one organization that could investigate the county executive, members of the county council, all the people that control its budget. And so if other departments don't have that protection, I still don't have a problem with, according it to the OIG.
And again, I'm not pushing for the impact statement. It's like, if we're gonna go this justification route, then I think it should be the impact statement, which is, things that we're considering at the state level already. Montgomery County, for example, requires impact statements around certain legislation and so forth. So I think it's if we go the justification route, then let's go all the way and get a full picture of what it means in this proposed change that you're making.
Well, I think we are, because when we talk about written justification, that's the status quo. It's already in there. And it's just a question whether we add language, and impact statement.
That becomes my confusion. It says right now, written justification.
right.
So are we saying written justification along with an impact statement? I mean, that in budget speak, which I don't.
I mean, we can clarify that the justification explains, the justification include an explanation of what the overall impact would be with this. So it isn't something separate. It is just requiring the county to take a closer look at what it is that you're not just cutting it. Here's what it would actually do. And I think we could even say in there, this is a best practice. You should consider doing this for all other budget cut areas too, if that's something they want to do, if that helps.
I'm if this helps at all, I'm willing to take a look at that little section and send something around for people to look at. I mean, I do think we the other thing, Mr. Chair, when you're going through your summary of, I think you soon I get to this, but was a review and potential modification of the justification language that exists in the code today. And I think, like I said, I haven't looked at it since the last meeting, but there might be some way to enhance it a bit and to include the concept that Joanne is describing. So if it's acceptable, I mean, I'm happy to take a look and see if I can suggest some language. I'll just send it around. And if it makes sense, or you can respond or whatever, but I think that's probably that would be fine with me. And I'm fine with everything else, of course, that's been suggested.
I think that'd be really helpful.
Sure.
Yep. Thank you, John.
You bet.
I think that's it for this topic for
Oh.
tonight.
Okay. So we have partial consensus, and we'll get that language, and then we'll come back to it in our next meeting. Okay. So then let's what's our time looking like? So let's move to the unrestricted access to materials.
This for tonight's purposes, I think will end up being a short discussion, because as we try to drill down into this, I mean, our subcommittee feels that we really need some additional input from different members of county government to figure out how to structure our recommendation. Because in concept, what we were saying is that the IG shouldn't, the activities of the IG shouldn't be monitored through people sort of monitoring record requests and tracking what they're doing or trying to figure out what they're doing. But how you implement that without getting really into what kind of, I mean, there's some basic questions that we still have. We believe we need further discussion on this point with both the IG and the CAO. In addition, the director of personnel, perhaps for the county, and the new IT director, whenever that person is on board. Because just simple things like whether all of the county's records that they're trying to access are electronic at this state, or if they're still hard copy records, how they currently protect areas of records which have medical information that's subject to federal legislation, mandatory reporter stuff that is supposed to be kept confidential. We don't know, just as a practical matter, how those things are playing out right now with record production. So we just need further information. Our suggestion was that we get a further just briefing, either the subcommittee or a small work group. I don't care how we structure it, but we need additional information for those people within county government. For a starting point, we think that it would be helpful to talk to both the IG and the CAO. And then based on their input, there may be a need for further up discussion with certain heads of agencies within the county.
Okay. Okay, then with that, Kathy, we will table that until we can get that further information.
Okay, thank you.
So we can move to the subpoena waiting period.
We did get some further clarification in writing from Ms. Madigan after the last meeting to sort of put in context the problems that they are having, which was very helpful. Our committee, the issue is this, there's a 90-day waiting period in the code right now before a subpoena can be issued. It's, as a practical matter, if you're talking about subpoenas to outside individuals or agencies that don't have a duty to cooperate with the office, there's no reason to have a waiting period at all. You should just issue a subpoena and get information. There shouldn't be a requirement that you go through some informal process with an individual or entity who's not obliged to deal with you at all. That's contrasted with the practice and experience when you're getting information from county government. With internal records, our belief is that the IG should have access to those directly, shouldn't need a subpoena, but there may be an instance where somebody who is required to produce records nevertheless doesn't, and a subpoena would be required. Our recommendation is when we're talking about internal government records that have been requested, if they aren't timely produced, and to us, that would be within 30 days with reasonable request for extension to be, not unreasonably withheld. After that, they should have an opportunity to issue a subpoena to get the records. The other piece of it is there may be county employees who have a duty to cooperate with the IG, but the IG wants records that are not county records from that individual. For instance, they're looking for bank records of some individual who works within some group, because the subject of the investigation would reasonably impact on deposits made in a person's individual account or something of that nature. Again, we are just suggesting those be treated the same way as other requests for county records. You make a request to the individual who has a duty to cooperate and presumably should produce the records. If they don't do so within the 30 days, that the IG could then proceed by way of subpoena. So for outside individuals, no duty to cooperate, no waiting period whatsoever. Shorten the waiting period to 30 days rather than 90 days if you're looking for records that are required either from the county or an individual within the county. But with that 30-day period, add language that would say subject to extension upon request, and the request for extension not to be unreasonably withheld or granted. So, and I think as a practical matter, the IG has been doing that with people now. If you're looking at really extensive production, 90 days may be completely appropriate, but if you're looking for stuff that's readily producible, 90 days is an awful long period to wait.
All right, any further discussion?
That, just to specify, that's 30 business days. Not calendar days.
I think it's just 30 days, isn't it?
It's 30, I mean, right now it's 90 days, not business days. So it would just be 30 days, not business days, because
So just 30 calendar days.
yeah,
I mean, it matters, right? If particularly talking about, throw 2 holidays in there, and so now you're down to 28 days, and the weekends you could be down to 24 days. So just to be specific, that's all.
yeah. And I mean, if people wanted, we're not wed to the 30 days. It could be 45, it could be 60, 90 just seems really long.
I think you protect against that somewhat by putting the language in, you can request an extension and that extension shall not be unreasonably refused.
Yeah, I mean, I don't, because then maybe generally we have responsible adults who play nice with one another. So like they can figure those things out. I think we just need to put
No, 30
timeline in
calendar
place.
days means something than 30 business days. It means something.
But I do
No, I
think
know.
Oh, okay. Okay.
And I think the reason I went to that, I mean, if you look at any of the court rules on sort of timeframes, they do calendar days unless it's a period that's shorter than 7 days is the general rule of thumb. That's why I went there in my head, but I'm not wed to the period, just the concept.
I'm fine with 30 days. I just wanted to specify particularly for the layperson who might be providing a statement or, just a person providing documentation. They got 30 calendar days or 30 business days, which is it?
Okay, agreed.
Okay. Joanne, did
I
you?
would, I think it has, I mean, for the reason that Janine just said, it really needs to be calendar days because frankly, business days are defined differently depending on who's defining them. And then you have to go look for a definition of business days and which holidays, state holidays, county holidays, federal, it's not worth it. So a calendar days is the way to do it. If people think 30 calendar days is not enough, let's extend the calendar days by a reasonable period. But I think it really clearly ought to be calendar days. And, again, we just have to, I mean, we saw some correspondence. There is correspondence in the public record between the IG and representatives of the county government, where it's sort of like, hey, I'm getting this to you as quick as I can, like we're in the middle of budget or whatever. You just hope that people will be reasonable and that neither side will use that period as a means to bludgeon the other. I guess every once in a while, people are going to be unhappy with each other, but I hope that it will, it's just sort of, we're going to get it to you as quickly as we can. And, if it takes a long time to produce it, because it's not just go get it from the file, or if there's a, I just make it up. There's a snowstorm and the county is ground to a halt for 3 weeks. You have to hope that people are going to be reasonable. But you set the rule and, people should abide by it.
Right. And our suggestion is we do this with an amendment of 314-107, which has this stuff all spelled out in the powers of office.
Yep.
Okay. Okay, and we would again ask our note takers to make note of that. And so then the recommendation, and I'm just simplifying the recommendation, that external subpoena there will be no waiting period, and for internal 30 calendar days with a reasonable extension when requested.
Yep.
Okay. All right, we have consensus, it looks like. And, no one objects. So good, we can move on to the next one. And that's going to be draft report notification and response period.
And we really touched on this earlier. And I think I don't know that there's much to add. This is another one that I think we need to put a pin in and get further comment back on what our proposal is so that we flesh it out and make it something that's workable.
Okay. Okay, does anyone have any problems or objections with putting table in this until we get through? Okay. All right, then accountability. This is a new one. So accountability mechanism. I think Janine, this may be under your.
Yes, and I'll actually go back to John for comment. I think it goes to some of the things we were talking about before with survey, peer reviews, but definitely a next Blue Ribbon Commission. John, you want to talk about some of those things? And
I'm sorry. What are we talking about here with respect
we're
to
talking about the accountability mechanisms. I think it ties in with the oversight of the IG's office.
Well, I mean, the oversight issue, if you want to sort of lump these together, I think we have obviously concluded that there should be no specific oversight mechanism. I think that was concluded fairly clearly by this group at the prior meeting. So we're certainly not going to change that fundamental and maybe arguably most important recommendation about the relationship between, the IG and those he or she might be investigating. I think that there are these lingering questions about how to be accountable. And as I said at the last meeting, you do have the code. It's a fairly blunt instrument, but it is an instrument that is available. And then you have the ability to, we can add in, and I mentioned sort of alluded to this earlier, we can add in reviews by peer reviews. We've said that the current statute is a little problematic. It says every 3 to 5 years. I don't know what that means. We can probably tidy that up. And then I do think it would be a good recommendation to say that that there will be a review. It doesn't have to be a blue ribbon committee, whatever we want to call it, a review of the status check on this to take a look at these issues once again. So accountability, it's a pretty fundamental issue with respect to IGs, and sometimes it can be very unsatisfying if you're concerned about the IG doing things you don't want the IG to do. That's kind of the price of having an IG. And at the end of the day, you have some mechanisms that are available. So you have, I don't know that there are any specific recommendations that the subcommittee or this commission is really in a position to make beyond the ones that we've described. I did, to kind of round out those issues, we did talk about this question about an advisory board, and it's probably the recommendation that I think I would almost say had the least consensus. Even within our subcommittee, and then even when we had a conversation about it at the larger full commission, and then we heard, I think, from the IG about it, about what function might that fulfill. The IG had suggested at one point that perhaps that could be an advocate for the office. I think, frankly, there was not much support for that among members of the commission, but there was the idea of having some sort of a sounding board to provide advice, feedback, and we talked about it, as you'll recall, in the context of sort of respected community leaders, in quotes, university president, retired judge, other folks in the community who could provide that. But admittedly, I think everybody's having a hard time getting their arms around what exactly that would look like, and whether we could develop some consensus on what that would be. So we probably should talk about that. I like the idea of that because I can see how it would be useful, but I also don't know that I can, I can't convince someone who doesn't want to be convinced that having that available is essential to the process. It's more of a gee, it would be nice to have something like that. But if the IG doesn't agree, if she doesn't think that function is a useful function, or if others on the commission don't see that as being particularly, useful or valuable, I don't view it as in my view, sort of as a top tier recommendation. I view it as it would be, is this an additional asset or resource that would be useful to the IG? So that's a variety of things, Mr. Chair, and I hope I didn't stray too far or combine too many. But those issues of accountability are, the big one. We're not going to have an oversight board. At least we're not going to recommend an oversight board. And there are some other things you can do that are either a little more attenuated or a little more blunt, to deal with an IG who is acting erratically or irrationally or irresponsibly. But fundamentally, preserving the independence means tolerating a certain amount of your inability to course correct, except for the term renewals and the intervention in the case of termination for cause and so on. It's a bit of a conundrum, but that's kind of the deal you make with yourselves as a government, as a community, as a jurisdiction, when you decide that it is important enough to have an IG.
And so we did receive information. I'm not sure if everyone received this, and if not, we'll send it to everyone, regarding what the city of Atlanta did with regard to their Office of the Inspector General. They have what's called a governing board of the Office of the Inspector General. I'll read very briefly the description. Says the governing board of the Office of the Inspector General was established to ensure the independence of the Office of the Inspector General. Among other duties, the governing board hears all appeals filed from adverse decisions and all motions to quash subpoenas issued by the Office of the Inspector General. It operates by its own bylaws. It's fully constituted. The governing board consists of 9 members with residency, employment, or business interests within the city of Atlanta, who are nominated by local civic, professional, and educational associations and institutions. So that's one jurisdiction, how one jurisdiction is handling that. I don't know if that's something we want to maybe take a look at, or whether we're kind of comfortable with, the recommendation that we make.
I'll just respond to that briefly to say, it's not that I'm 100% comfortable with the status quo. It's that it is an imperfect situation to which you submit as part of the benefit of having an inspector general operating in the jurisdiction. I mean, you can imagine scenarios in which you wish you could do more to intervene, but that's sort of the as I said, sort of the price you pay for having a strong and independent IG. I am completely opposed to the Atlanta idea. I just cannot imagine recommending the creation of an entirely new body with appellate jurisdiction over the IG. That's not exactly the same as the board that were an oversight board, but it's a whole kettle of fish that I just don't see any justification for introducing into the discussion at this point.
This,
I have a question regarding what John was describing out of your subcommittee regarding this potential peer review. I think that you may have said 3 to 5 years. I'm not sure. I believe that the IG's term is 5 years. So I guess if you're going to have a peer review 5 years after the commencement of a term that ends at 5 years, I guess I'm not sure what the value of that is. But maybe you meant 3 years. So there's.
I didn't. I mean,
and
what I said 3 to 5 because
Okay,
I was picking a little bit on the current statute, which says 3 to 5 years, which I think is a kind of an odd way to write a statute. And I was suggesting that the statute should say, the ordinance should say, every X number of years there will be a peer review. And Cindy, I think the question of how to how to sync it up. I don't know if you can sync it up perfectly with the IG's term or not. Someone needs to just sort of think that out in terms of a little bit of a timeline. I think what we were saying as a subcommittee was 3 to 5 is no way to write a statute. And, my own preference would be more for 3 than for 5, because I think it's a more regular periodic review by peers. So, if I had to make a recommendation on that specifically, I would recommend that peer review portion of the statute, and I don't have it in front of me, would be that it be 3 years, not 5 years. And it certainly shouldn't be X to Y. It should be a number. And 3 would be my preference. If that, so hopefully that fits my earlier comment.
Thank you. And my other question about this is, I think that you're meaning that this peer review, the members of this peer review effort would be coming from, for example, I can't remember, the Association of Inspector Generals,
Yes.
whatever that
Yes.
is. And one of the questions I have, it's not that I have an opinion on this, I just am not sure I understand what kind of information they would have. I mean, it occurs to me that, like, if they went through all the IG's records, well, then they're going to be looking at things that are confidential. And what does that mean? And do we have to consider the protection on that? Maybe what is being contemplated is that they would simply read the published reports. But I'm just wondering if there's any thought about the information that the peer review people would be reviewing.
I think others can comment on this, and maybe even the staff who did the research can comment, but it seems to me that there's sort of a protocol, and I can't recall it to mind, but we heard from those folks, and I think there's a protocol for this kind of peer review, the things they review, the things they don't. Obviously, it's not intended to break confidentiality, et cetera, but it's kind of a soup to nuts policies and procedures and how you do things and so on. I'm sure we could get a refresher on that. I'm sure we could probably even get a scope. I don't know if there's a template for it or a checklist for it or a topics for it. But I remember when we had the presentation, it seemed, fairly rational, sensible and reasonable to me that you would have peer IGs come in. And I think, for example, I think when Inspector General Cumming from the city came in, I think she's very involved in that organization. She said that she's had panels come and review, and she's also participated on peer panels. It's kind of like sometimes you get reviewed and sometimes you do the reviewing.
Right.
But I think it would be, if we've lost track of exactly what that looks like, we certainly could be reminded of what it is. But it struck me at the time as a professional, peer review by IG peers that did not create any confidentiality or, those kinds of concerns.
Yeah,
I'm not
I-
saying that I'm opposed to it. I'm just simply saying that
Yeah.
I think that for me, before actually voting on this, I'd really like to have some more content.
Sure.
And I have a question too. Isn't the peer review, if the IG is part of the association, doesn't it just happen? I guess I've never been clear around like how that comes to be, but I thought it was just like if you're part of it, at some point they would be reviewing your office.
yeah, I think the Association of Inspector Generals are the ones who conduct peer review, and the way it works, according to the Inspector General, the way it works is you go through a peer review. I mean, you've got Inspector Generals; they know what they're doing. That gives me a lot of comfort. I'm not concerned about them breaching confidentiality. They're already going all around the country and doing it, and I assume they know how to do it. And in exchange for that, the Inspector General who gets peer reviewed has to make herself available to conduct peer reviews of other Inspector Generals.
Yeah, and I believe that would be by request of the IG. I don't think it's automatic. And even if it is automatic, there's no requirement that the county inspector general be a member of the Association of Inspector General. So we're trying to, make sure that within the county there's a mechanism for peer review. And then, also in the audit world, peer reviews are required. So.
And particularly if it's by request, that's why you put it in the statute, so it's not discretionary. And I'm sure that I feel like this is one of those moments where if the IG is an attendee, as she typically is, she's probably screaming, "Let me just explain this to you." So I think we should just take whatever time we need, whatever group of us or however we want to do it, and get comfortable with what exactly this looks like so that we can address Cindy's reasonable questions and figure out what that peer review process is. And if we're comfortable with it, and if we need to tweak the statute and so on, I think that to me, it falls into that category of something we clearly want to do. We want to get it right. We ought to get some practical advice to make sure that we don't have any loose ends or lingering questions about it.
Okay.
Do we have any research on whether this is at all a typical sort of thing to have in the IG legislation, that there would be this kind of, in other words, for people who do not have oversight, that they have in their legislation this form of peer review? Are there examples of this?
I think it's actually in the model legislation. Because I thought the county had kind of pulled that from the model legislation. Well, they pulled it from another statute, which maybe came from the model legislation. I can take a look at that, but I think that's where we are. And of course, it would come at the end. But yeah, section 14 of the model legislation is quality review. And it says that, audits, investigations, inspections, and reviews shall be subject to quality assurance reviews by an appropriate professional, nonpartisan, objective group every 3 to 5 years. A copy of the written report resulting from the review shall be furnished to the appointing authority and oversight board. The report shall also be made available to the public. So I don't know, how common it is or uncommon, but it is considered best practice by the Association of Inspector Generals.
I think to me, the mystery here is, I don't really know what this is. I've obviously never seen one. And although maybe if they make them public for their other ones, maybe we can see a couple. But I would just like to understand, what it is. But thank you very much for all the effort you guys have done on this issue. So hard.
By the way, I'd forgotten that the 3 to 5 came from the model. That as Tom just read it, that's where 3 to 5 came from. And I think whenever the code was adopted in the county, someone just borrowed from the model without realizing that. I think you were supposed to pick one. You weren't supposed to say 3 to 5, but anyway.
Yeah, I would agree with the suggestion it'd be 3. Yeah.
And I think regarding the peer review, if it's helpful, it looks like Baltimore City just went through their process or they're still going through it. So maybe it's an invite back to IG Cummings to ask her what that's looked like. How has it been working in Baltimore City? What did they do and so forth? If we can't go directly to the association.
And she says it is published, it's public, it's on their website, so we can go to the website and see it.
Okay. I just wanted to, can I address the question of the advisory board?
Yes,
I've given this a lot of thought, and I've finally come down on the side of, I don't know that we need an advisory board. I think the peer review every 3 years is sufficient. The advisory board is, most jurisdictions don't have it, so it's not best. I don't think it's best practice to have an advisory board, and we have really struggled with how do you fashion something like that where without stepping on the toes and interfering with the work of the IG, and it's difficult to do. And so I'm not sure what the, how much benefit there would be from it, because Inspector Madigan said that, she has her mentors, she has people she can call the Association of Inspector Generals. So if she needs advice, there are sources of that advice available to her. And I don't know that we need to create a body to supplement that, because it's hard to avoid the risk that you might do it in such a way that you're going to interfere with the functioning of her office, which we all agree, cannot be done.
okay. And so if, because we've combined oversight and accountability here and advisory board into kind of one discussion. And it sounds like before we kind of finalize any recommendation on this, that there may be some unreadiness and just people want a little bit more time to think it over and maybe gather some more information. And so if it's okay with everyone, we can table this as well until there's.
Mr. Chair, I did have a question.
Yes.
Just who is the report going to besides the public? Then at the oversight, if there's not an oversight board receiving it, who else is receiving it? The public, the IG's office, and what entity?
In terms of the peer review?
Correct, yes.
Okay. That's something we can find out. Yeah, I don't know off the top of my head. Yeah.
If it's available to the public, I would think they could just post it on their website or something, if and people could access it as they want. But I'm speaking off the top of my head. I don't know the answer to that question.
Could I just, for the record and for those who are also listening and et cetera, just to clarify my understanding. First of all, Tom, I have no objection whatsoever to not having an advisory board. It just seems like we can't. It's sort of a board in search of a purpose, and that. So I don't really have any problem with that whatsoever. People may feel differently, and we can continue to talk about it. It sounds to me like we have a little bit of work to do to understand better what the peer review process looks like, so we're comfortable with it. And there are a couple of aspects that we've talked about here. But the reason I'm saying what I'm saying now is the chair has just talked about tabling this, and I think we are tabling part of it. We are not tabling the question of oversight board, right? I think we crossed that bridge a meeting ago. I don't want anybody, unless people disagree, to misconstrue what we're doing here when to say that we are somehow tabling that aspect of it, because I know people are paying close attention, particularly to the question of oversight. Mm-hmm. So I just, I assume everybody agrees, but I think we want to be absolutely clear that the sort of further discussion part of this relates to the question of this peer review and what that looks like, and making sure we understand it. But we're not revisiting the question of whether there should be an oversight function, because I'm afraid if that's misconstrued, it will set off all sorts of concerns which are simply not valid and not true. Fair enough.
And does that also include advisory board? Because it doesn't seem like unless I'm hearing wrong, it doesn't seem like anyone has any ideas around what that would look like either. So I'm not sure why we'd be tabling that if we don't have a reason for it.
As the person who presented it, and not advocated for it, I might point out, but presented it, I'm happy to resolve the issue of advisory board this evening as well, but that's up to the chair and up to my fellow members. So, that's as whatever the chair decides, but I just do not want to see a story that says commission is revisiting oversight board, because I'm confident that that is not what we're doing here this evening, unless someone feels to the contrary.
Okay, so let me do two things. One is we can separate those out and just see where we are in terms of consensus. The other is that for the record, that we are formulating recommendations, and these are not final recommendations. We have not finalized them, and so we're having discussion right now that hopefully will lead by the next meeting final recommendations, which means that there can be changes. That we may gain information that we don't have tonight that changes something. So just want to be clear about that. But to your point, John, we'll separate those out. So with regard to creating any type of an oversight board, we are not recommending that. So let me see if that's our consensus on that we are not recommending an oversight board. Okay, so we're clear on that, John. And so the second one is the discussion with regard to creating an advisory board. Are we saying a thumbs down to that as well, or do we need more work on that?
I think it goes back to my question about who receives the report. Is there an entity that receives it that's going to assist with the recommendations that comes out of it? Is that an advisory board, or that could do that, as opposed to giving it to the county to take action against, because they're not trying to, what's that peer review? So you do a peer review for the sake of doing it. So what happens with it? The public can't drive any change. They can read it. So I'm not sure if that's the entity that should receive it. I'm not, that's why I'm not going to thumbs down on it. Advisory board, but I don't know if that's what it's called.
And I guess my concern with an advisory board, it's just something like that shouldn't go to an advisory board. I don't know what they'd be advising on, but it wouldn't be where, recommendations coming from the association, maybe regarding changes, that they'd be the ones dealing with it either. I mean,
I just don't know who
what goes to.
Because we talked about it under an accountability mechanism. Maybe it's not an accountability mechanism. It's just information. I'm not sure.
In the chat, Anne says it goes to the IG. And no one. So I guess the IG, I thought it went to other. It is public, but I didn't realize it only went to the.
It would be public, and then for the use of the IG to make improvements within the organization. Is what the peer reviews. When I was IG at the time, we didn't have peer reviews for the investigative functions, but we did have peer reviews for our audit function, and it was the same thing that we utilized that to make changes based on the recommendations of the peer review, and they would come back in to see if we made those changes in the areas where they found us to be deficient. So it's kind of self-regulating. In that instance, it was. We can do more work to see if that's the same case with regard to the association's peer review. But the fact that it's made public, that kind of gives you some oversight. If no one wants a negative review made public, so it would raise questions. Any other discussion? So again, I guess we're still back to this whole piece about advisory board. Is that something that we need further discussion on, further research on, or do we want to just say no? For lack of background.
I think it can wait till next time when we have some more answers.
We-
on some of the other things.
Okay, so we will table advisory board, and we will table accountability mechanism so that to answer any questions that we have with regard to peer reviews.
Right.
Is that fair? Okay.
I just have one question. Like, if we're going to table advisory boards, can, I guess, the subcommittee, if there's capacity, I know it's during the holidays, can you look at what the criteria would be if we were to even explore an advisory board? I think one of my concerns is, I mean, I think this is just Baltimore County, it's statewide. We create these commissions and boards, we come up with criteria to, you know, make it function the way that we want, and the council, you know, goes and kind of does its own thing. So you could very well create a dynamic where there's a body that doesn't, you know, really isn't functioning in support of the IG's office, you know, that is kind of over that office in some way. So again, I guess, what's the criteria? How do we get the right people on the board, especially if the council and the county executive are going to be the ones making the appointments?
And that's just kind of my point. I think it's fraught with danger that it could morph into something we don't want to see. And I don't see any great benefit to having an advisory board when the inspector general doesn't seem to, you know, think that she needs it. She has ways of talking to other people when she has a problem or a question.
So I think for me, it's that I definitely have no idea what the advisory board would look like, would mean. I don't know whether the word advisory board is even an appropriately descriptive term for whatever it is that people are variously thinking about something like this. And I think my concern is simply that I really just don't understand what this peer review report is. As I said, I don't know what goes into it, what information they have. I don't know what comes out of it. Maybe the peer review report will turn out to be sort of an advisory sounding board. You know, maybe that's what it is. I right now don't know. The other subcommittee was looking into this peer review report, but I have not. That was not what was in our subcommittee. And, you know, if we want to say, well, it would be called an advisory board, but I don't know what we might all think might be some additional even support of the IG after we actually get to learn about this peer review. That was the reason I said, can't we just kind of put this off until we see what the peer review is? If everybody feels strongly, however, that we decide right now not to have anything that looks or smells like an advisory board, regardless of what it's called, then I'm certainly not going to, I don't feel I need to be the only holdout. I will go along with the rest of the consensus. I do feel very, very strongly on us learning both what comes into, what information goes into, and what comes out of this peer review thing. Lots of people have it. It's probably a really good thing. So,
for the record, I'm okay with tabling the discussion. I just wanted to make sure we were thinking about who would actually be serving on this, what it would look like if the elected leaders are the ones making the appointments.
Okay.
and also, I want to say it's not that I'm thinking there should be an advisory board. I just am really focused on wanting to know about the peer review report.
But I mean, we just got the link to the Baltimore City one. It's a 4-page document. It's not an extensive. I mean, I'm scanning it right now. It's helpful, but I think it clarifies some of those questions in terms of what they've done and the type of detail you get in response. So that's helpful.
Okay. So do we want that subcommittee to just kind of pull some more information for us on that? I'm still trying to make sure I understand where everyone is on that. So I know Joanne said you're okay with tabling, and Cindy's okay with tabling. Tom, I think you're just saying, no, there's no need to even discuss advisory board any further.
But at the same time, I don't have a problem with tabling it so people can, get the information they want before we make a final decision.
I mean, I'm fine with that too. I worry we're going to circle around the same conversation again, because I don't know that there's a lot more I mean, and my sense of this is none of us, we're all in agreement on the lack of an oversight committee
Yeah.
or anything that we call something different that's essentially doing that function. There may be some benefit to having some feedback given to people about performance because you can de-escalate situations before they, but to try and come up with some mechanism to formalize and mandate that, I think is just a rabbit hole we shouldn't go down because if there are, we've got intelligent professionals that are fulfilling the roles here. And if they want some input and feedback, they know how to get it. And whether they choose to ask for it or not is kind of an individual thing. I think we're going to have the same conversation at another meeting where we all think intuitively, feedback is a good thing, but trying to mandate it in a way that's not an oversight board called something else is, I think, an impossible task. So I right now would vote to just table the discussion and go with our main recommendation, but.
I mean, I am certainly all in favor of there being no oversight board. I left the last meeting unclear what the advisory board even was. Was it mentoring? Was it what? There isn't any particular other kind of board or organization that I am imagining right now that I think there should be, right? But it is a little hard for me to say there should be the advisory board when I don't know what it is. If we want to put content to it, if somebody wants to say here, by advisory board, we mean a mentoring organization, I would agree that is not needed and we can say no. But if we, I guess in order for me to say we don't want to have it, I need to have definition as to what it is. So is that what we're talking about? A mentoring board? That was one of the things. So if mentoring board is what it is, I will say yes. We can just say no to it.
I think the problem was we couldn't come to a consensus as far as what the board would consist of because, every iteration was fraught with difficulties.
Okay.
So I don't think there was ever a specific proposal for we should have an advisory board that will do this. There was a lot of discussion, but no real decision made in terms of what it should look like, is my recollection from the prior meeting.
So then what is it that we're now saying that we don't want?
An advisory board. I mean, there is none. No specific one has been recommended, but we're saying whatever you come up with, we don't want it.
This has become a bit ephemeral. I mean, I think the way I would say it, Cindy, is, does anybody think there's a need for an augmentation of any kind, mentoring or anything else? If the answer is no, then we don't need this thing. I think it insinuated itself into the discussion because somewhere along the way, there was a discussion about, well, we know we don't want an oversight board, but is there a room for some other kind of board that would provide some kind of support to the IG and things like mentoring, advice, feedback, counseling, I don't know, whatever, all those things kind of came up. And I think nothing ever really resonated. And I think we're now sort of getting to the point where we're like, well, I guess we've now beaten it sufficiently to conclude that there's really no compelling reason to have such a thing. I also completely agree with you that we probably would be helpful for us to understand a little bit what the best practice, what the peer review looks like. But I really don't know that that's the same issue as the advisory board. And I think to some extent we sort of squished them together here unnecessarily. I think I'm going to conclude ultimately that we don't need an additional board of any kind, but I'm certainly willing to wait till the next meeting to finalize that thinking based upon a little more insight on the peer review and maybe a little bit of time to think about it. So that's what I'm saying. I think no one knows. We were trying to sort of fill a gap that may not exist, and if there's no gap, then there's no need to fill it. End of story. I don't. That's the way I'm looking at it.
Yeah, and I think it kind of started with the whole piece of accountability mechanism. So if that's the overarching, that we're looking at, then we need to come back and maybe have more of that discussion, and that's where the peer review would fall into more of the discussion.
Well, okay, so as I've said, I am absolutely supportive of the no oversight. given the range of possibilities as to what an advisory board may have been that Tom and John have just said, I'm okay with saying no to that, but I really did very much start this and last meeting, not understanding what this advisory board would be. It seems that nobody really knows what it would be. And since nobody seems to find a role for it, that I guess we don't need to have this undefined role.
I think that's a fair summation.
So that, because we're coming, we're getting close to our end time. And so we will kill the advisory board. Unless someone else, just really wants to have that discussion. I really don't think we're going to get anywhere by continuing that discussion. And we will table the accountability mechanism with regard to peer review, so that we can have, come up with more information, with regard to that. And if there is some other form of accountability that, we come across that we want to discuss, we can, do that as well. But it would not be in the form of either oversight board or an advisory board. Is that fair?
Mm-hmm.
Okay, so we won't have that discussion any further. And okay, thank you. And so that covers, we've covered really all of our topics. I don't believe I didn't hear any new topics come up tonight that we need to add. And so let me stop right here. Yes, Tom.
There was a new topic that just came out last week, Baltimore County culture and the OIG. I'm not sure what it was trying to get at. It sounded to me like, there's been some testimony that there's been tension and friction between the OIG on the one hand and, the administration on the other hand. And how can we improve that? Is that, but we were just seeing that as a topic for the first time last week. Is that what it's getting at? Is that what?
And that one I'm not.
Baltimore County culture is kind of an amorphous concept. So I wasn't sure what they were talking about when they added that new topic.
I think, Tom, that may be a reference to what became sort of incorporating the OIG into the county kind of government culture, which we covered. I mean, I think it was, I think that morphed into things that were more artfully named in my mind. It was, how you make this part of the fabric of Baltimore County life. How do you, it is the same things we were talking about in terms of the rolling out of the new policy, code of conduct policy and the trainings and the, that sort of stuff. I don't think it was, I think it was covered in that way. And I think that was the intent of it. It maybe wasn't as artfully phrased.
Well, that's fine. And my reaction to it was that in terms of making this incorporation, that all the things that your subcommittee is recommending will get us a lot closer.
Right. Okay. So thank you, Tom. So it's not a standalone topic, but it covered several areas.
Okay.
All right. Are there any other concerns or topics that you think we need to add before we won't discuss it tonight, but that we need to add for the next meeting? Okay. So let me thank you for our discussion tonight. I think it was a robust discussion tonight, and it will be a basis for our next meeting, which still needs to be scheduled. And I can note here that at the end of the last meeting, the subject of requesting an extension for our work was raised, and several of you supported that idea. A request was submitted to the county executive's office for a 1-month extension of our work, and that request was granted. And so our interim report is now due on January 17th, and the final report will be due on February 16th. And so therefore, I'm going to suggest that we hold our next meeting the week of January 10th. And the University of Baltimore, I understand, is closed until January 3rd, and they will not be able to make the registration link public until that point in time. And of course, we also know that the commission members need time for the holidays as well. I'm sure all of you are going to be very busy as well. And people won't be in offices over the next few weeks for any last minute fact finding that needs to be conducted. This is probably the worst time to request additional information from anyone, not only in government, but in any entity. So, so based on the information some commission members supplied, it looks like the evening of Thursday, January 12th would work best. So let me just put that out there. Is everyone available for Thursday, January 12th?
I need to check.
Works for me.
Okay,
Would it be the same time, 5:30?
5:30, yes.
Yeah, I'm good too.
Okay.
Yeah.
Okay, Tom and
Unfortunately, I'm using my phone, it's the same device. The Thursday, the 12th, you say?
yes, 5:30.
Yeah, that's fine.
Okay, Tom.
Oh, I said, yes, it's good with me. Yes.
Okay, I didn't hear you.
That's okay if it's fine with everyone else. That's fine.
Okay, and Joanne said, okay, good. So we will ask staff if you would schedule that for Thursday, January 12th at 5:30. Okay. Let me make sure that I'm covering everything. And so if we can try to get a meeting on your calendars for early February as well. And to find out if you're available either Thursday, February 2nd or Thursday, February 9th for a final meeting. So if you could,
I could make either of those dates.
either of those, okay.
32nd would work best, because for me at least, because then we're going further into the legislative session.
Okay. So is the 2nd good for everyone?
It is.
Okay. Other than the fact that it's Groundhog Day, anyone opposed to meeting on Groundhog Day?
I knew there was going to be a Groundhog Day joke somewhere in here, but I'm okay. Okay as well.
I couldn't let it go, you know?
I know.
Okay, so we will use that date then as our final meeting. Thursday, January 2nd.
Can someone just get those dates out to us in some sort of, at least to hold the date, no details necessary, as soon as possible, please?
Okay. I'll ask UB, is that possible?
Ann says
Yeah, I'll
yes.
send them out tonight.
Okay, great. Thank you.
Tomorrow would be fine too, Ann.
We're closed after tonight.
All right. Well, then,
And is trying to have a holiday, so. Okay. So do any commission members have any other commission business to discuss? If not, then that is the end of our agenda for tonight. And so as usual, on behalf of the county executive and the citizens of Baltimore County, I want to thank our members of the commission for volunteering your time and expertise to carry out this important work with the commission. Can I get a motion to adjourn?
So moved.
We adjourn.
Okay, and may I have a second? I had two, so I'm going to take that as a second. With that, so thank you again, everyone. And again, have a happy and safe holiday. And we look forward to seeing you in the new year.
take care.
Thank you.